503.030. I understand you've already ruled on that, but I'm renewing my motion for the record.
All right, thank you. So I think, as I had said yesterday, I believe 503.120 precludes the self-protection instructions, the protection of other instruction, the choice of evil instruction, choice of evils instruction. I also wanted to say just a little bit more about that. In reading the case law regarding this justification defense, the defendants that I read about in the cases that discuss choice of evils acknowledge breaking the law. They say, I broke the law, but here's why I broke the law, which was to avoid an even greater evil, such as a defendant who, say, is a convicted felon, not allowed to be in possession of a firearm, and he finds a firearm, say, out on the street and picks one up and says, well, I did this to preclude a young child from getting hold of it and causing injury to the child. So he is saying, yes, I know I'm not allowed to be in possession of a firearm as a convicted felon, but I did this to avoid a greater evil. That's not what Mr. Hankison said on the stand yesterday. He was asked whether he thought he had done anything wrong, and he said no. Therefore, he's not saying that he chose one evil over an even greater evil. So I just don't see, in light of that, as well as I think 503.120 precludes the giving of the choice of evils instruction because of the wanton nature of the offense that is charged here, wanton endangerment. So, and then as far as the Graham versus Connor, again, I think that applies. My reading of that was a civil rights action. I've not been cited any case law that says that is to be applied in a criminal case. I don't think there's any different standard for a former police officer on trial. It doesn't change the law relating to wanton endangerment than it does for any other citizen of the Commonwealth. So I will give the instructions that I have included in the email that I sent to you all last evening, which are the 3 counts of wanton endangerment in the first degree. All right, so we'll finish copying those. Anything else to put on the record?
Not on behalf of the defendant, Your Honor.
No, but I do have one issue, I guess, in the nature of motion and eliminate. In Kentucky, well, in most places, it's well settled that the golden rule argument being that a attorney cannot, either prosecution or defense, cannot ask the jury to put themselves in the shoes of the defendant or a victim. Case States versus Roman, but it is well settled. I also have an email or a memorandum sent by email from one of our appellate attorneys that cites some cases. Most of them are old cases, and most of them are, because most of the time this has happened, it's the prosecution who's done it rather than the defendant. So we ask that in closings, the golden rule prohibition against asking the jury to put themselves in the shoes of the defendant be imposed.
All right. Mr. Matthews?
Judge, that pretty much eviscerates my closing argument. I mean, I think the jury is entitled to be asked to put themselves in Brett Hankison's position because they're supposed to judge it from the moment that it occurred, not with 20/20 hindsight, which is what if you say, what do you think about what he did today? Well, what he did today may not be as reasonable as what he did on March the 13th in the 15 or 20 seconds that this whole incident occurred. And I think that the jury can be asked to try to imagine themselves in that position. Again,
well,
that's...
I think there's a way to phrase that without saying to the jury, put yourself in Mr. Hankison's position on the day in question. and the law does not allow that to be done. So I'm going to sustain the motion of the Commonwealth that you not do that, and as well that Ms. Whaley doesn't do that regarding Cody Etherton or Chelsea Napper or the 5-year-old.
Judge.
All right, counsel, would you approach for just a moment, please? All right, good morning, ladies and gentlemen. Anything to report from the break last night? Very good. All right. You've now heard all of the evidence that you're going to hear in the case, and it will soon be time for you to deliberate the case. So at this time, I want to give you some general instructions before I read to you the law of the case. Each juror must decide this case in his or her own mind, but only after impartial consideration of all the evidence with all of the other jurors. You should not be concerned with the rulings that I made during the trial, for I tried my best to follow the rule of law in making my rulings. I know many, if not all of you, have taken notes during this trial. That's perfectly fine. The purpose of the notes is to refresh your own memory, not to tell another juror that his or her memory is wrong because they differ from what you have written down in your notes. Once you go back to the jury room to deliberate, the exhibits will be brought back to you. The attorneys and I will go through those exhibits before they're sent back to you to make sure that everything that has been admitted into evidence is sent back to the jury room for your consideration. If you feel the necessity to ask a question of the court while you're deliberating, you would need to write that question down and then just knock on the jury room door. A deputy sheriff, Anthony, or one of the other deputies will be stationed outside of the jury room door. Will bring me that written question. I'll then gather the attorneys and the parties together. We'll discuss whether we can give you an answer. Now, I do need to tell you, there's really very little that I would be able to answer for you, such as if you wanted to know a word in the instructions, a specific definition. Unless that definition is already provided, I cannot add to the instructions once I read those to you, which I will do shortly. Or if you're saying, I wish I'd had a photograph of this, or I wish I had seen this piece of evidence. If it wasn't admitted into evidence, then I cannot send it back to you while you are deliberating. As I said, Deputy Sheriff will be posted outside of the jury room door to make sure that no one interferes with your deliberations. The original set of the instructions, I've put a star in the corner, and I've also signed the last page of the instructions. So when you select a foreperson, and that's one of the first things that you should do when you go back to the jury room, I will send the original set of the instructions back with the exhibits, and the foreperson should take possession of that original of the instructions and record the verdict on the original, if you would, please. I will give a copy of the instructions to each of you to read along as I'm reading those to you. The closing arguments which you are about to hear, like opening statements, are not evidence, but as I told you as we were getting ready to get started with this trial, they are very important. The attorneys will be stressing to you those points that they think that you should focus on during your deliberations. Of course, the decision as to what you actually do focus on is completely up to you. All right, so at this time, I'm going to read the instructions to you, the law of the case. So Anthony, if you wouldn't mind passing these out to the jurors. All right, thank you. All right, in the case of the Commonwealth of Kentucky versus Brett Hankison, jury instructions. Your first duty upon returning to the jury room is to elect a foreperson. Then, under the evidence presented to you in this case, you may find the defendant, Brett Hankison, not guilty, or you may find him guilty of one or more of the following offenses. wanton endangerment in the first degree as set out in instruction number 4, and or wanton endangerment in the first degree as set out in instruction number 5, and or wanton endangerment in the first degree as set out in instruction number 6. Instruction number 1, unanimous verdict. Your verdict must be in writing, must be unanimous, and must be signed by one of you as foreperson. You shall use the verdict forms provided at the end of these instructions. Instruction number 2, presumption of innocence. The law presumes the defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Instruction number 3, definitions. Serious physical injury. Physical injury which creates a substantial risk of death or which causes serious and prolonged disfigurement, prolonged impairment of health, or prolonged loss or impairment of the function of any bodily organ. Wantonly. A person acts wantonly with respect to a result or to circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstances exist. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Instruction number 4, wanton endangerment, first degree, as to Cody Etherton. You will find the defendant, Brett Hankison, guilty of wanton endangerment first degree under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in this county, on or about March 13th, 2020, and before the finding of the indictment herein, he discharged bullets from a handgun into apartment 4 of 3003 Springfield Drive that entered apartment 3 of 3003 Springfield Drive, which was occupied by Cody Etherton. That he thereby wantonly created a substantial danger of death or serious physical injury to Cody Etherton. That under the circumstances, such conduct manifested extreme indifference to the value of human life. If you find the defendant guilty under this instruction, you will say so by your verdict and no more. There will be a further proceeding at which you will fix his punishment. You shall use verdict form number 1 in reaching your verdict under this instruction. Verdict form number 1, wanton endangerment first degree as to Cody Etherton. We, the jury, find the defendant Brett Hankison not guilty of wanton endangerment first degree under instruction number 4. There's a line there for the foreperson signature if that is your verdict. Or we, the jury, find the defendant Brett Hankison guilty of wanton endangerment first degree under instruction number 4. Again, there's a line there for the foreperson signature if that is your verdict. Instruction number 5, wanton endangerment first degree as to Chelsea Napper. You will find the defendant Brett Hankison guilty of wanton endangerment first degree under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in this county, on or about March 13th, 2020, and before the finding of the indictment herein, he discharged bullets from a handgun into apartment 4 of 3003 Springfield Drive that entered apartment 3 of 3003 Springfield Drive, which was occupied by Chelsea Napper. That he thereby wantonly created a substantial danger of death or serious physical injury to Chelsea Napper. That under the circumstances, such conduct manifested extreme indifference to the value of human life. If you find the defendant guilty under this instruction, you will say so by your verdict and no more. There will be a further proceeding at which you will fix his punishment. You shall use verdict form number 2 in reaching your verdict under this instruction. And then verdict form number 2 is the same as verdict form number 1, except that it applies to Chelsea Napper. Instruction number 6, wanton endangerment first degree as to Zayden F. You will find the defendant, Brett Hankison, guilty of wanton endangerment first degree under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in this county, on or about March 13th, 2020, and before the finding of the indictment herein, he discharged bullets from a handgun into apartment 4 of 3003 Springfield Drive that entered apartment 3 of 3003 Springfield Drive, which was occupied by Zayden F. That he thereby wantonly created a substantial danger of death or serious physical injury to Zayden F. That under the circumstances, such conduct manifested extreme indifference to the value of human life. If you find the defendant guilty under this instruction, you will say so by your verdict and no more. There will be a further proceeding at which you will fix his punishment. You shall use verdict form number 3 in reaching your verdict under this instruction. And then verdict form number 3 applies to Zayden F., the 5-year-old child. And then I have signed the instructions at the end on the original and dated them. All right, this time you will hear closing arguments from defense counsel, Mr. Matthews, and I will tell you that each attorney has told me that they will take about an hour in presenting their closing argument to you. We will take a break between the 2 closing arguments. Mr. Matthews?
Thank you, Your Honor. May it please the court, thank you. Ladies and gentlemen, good morning. Hopefully I will not take an hour, but I don't know. I haven't timed it. Ladies and gentlemen, I'd like to start out by thanking each and every one of you for agreeing to participate in this trial. We've been here, it seems like, for long days, for a lot of days. We're now at the end. But I know you've paid close and careful attention. I've seen all of you during the course of this trial taking notes and paying attention. That's all we ask you to do. I'm not going to go delve into all the facts. You've heard facts over and over again, and I don't think there's a whole lot of dispute between the Commonwealth and between us over most of the facts. Some of the facts are disputed, but most of the facts are not. The big dispute in this case is how do you interpret those facts? And before I get into a lot of things, I would like to, there are a few issues I'd like to discuss preliminarily. First and foremost, I think everybody in this courtroom and probably everybody in this world agrees that the death of Breonna Taylor was a terrible thing. As Brett Hankison said yesterday, it should not have occurred. I think we can all agree on that, but I think we all know that this case is not about the death of Breonna Taylor. It's about Cody Etherton, Chelsea Napper, and their son Jaden. And what happened to them is a terrible thing also. But fortunately, none of them were physically injured. You saw particularly Chelsea the other day talk about the trauma and the emotional upset that it caused she and her family. And there's no disputing that. You'll have defendant's exhibit number 1, and I apologize for sounding a bit callous here, but you'll have defendant's exhibit number 1 in the jury room with you, which is a copy of a civil lawsuit that they filed against Louisville Metro government, the Louisville Metro Police Department, Detective Brett Hankison, and 8 or 9 other police officers, which seeks as compensation for what they've been through in 3 different counts, $12 million and $1, 3 times over. So for a total of $36 million and $3 is what they're seeking for compensation. And while I suspect they're not going to get that kind of compensation, I believe they probably will get compensated as a result of this. That's not going to undo what happened on March the 13th, but I think it would go a long way toward alleviating some of the emotional distress that they've been put through. Ladies and gentlemen, there's a common denominator to this case, and that person is not on trial here. That's Kenneth Walker. He's the fellow who fired the bullet, the initial bullet that struck Sergeant John Mattingly while he was in the performance of his duties as a police officer, serving the search warrant at 3003 Springfield Drive. The search warrant itself was something that the officers all had a right to be where they were. They were doing what they were instructed to do. The problem is, with that search warrant, is that the officers were ill-prepared to go out to 3003 Springfield Drive, as it turns out. You know, we've heard testimony about no-knock search warrants, and you have heard those described to you as what that is. We've heard that this was served as a knock-and-announce warrant. The no-knock warrant is how it was issued. That is, the police had the right to go out to 3003 Springfield Drive to Breonna Taylor's apartment and just break in that door and search for the documents and whatever other contraband they may have been looking for or could find. Somewhere along the line, they were told not to do that. Go out and knock and announce and let the folks know we're here. And the reason that was done is, number one, the information provided to the officers who went to 3003 Springfield at the briefing at the CID office on Ormsby before everybody went out on these different search warrants was that at 3003 Springfield Apartment 4 there was a single female living there who had no children, no pets. There was nothing there to indicate that there would be any problems with the execution of the search warrant, no issues. So it was considered a low-risk entry that they were going to make. So be courteous, knock and announce, and let somebody know we're here and give them a chance to answer the door. Well, what happens? The police show up, they knock and announce, and there's been a lot of controversy about whether knocking and announcing occurred. Every officer who testified here said that we knocked for a prolonged period of time. We announced ourselves as police officers, and the issue is, are the officers telling the truth? Well, we heard from Aaron Sarpay, the neighbor from upstairs in apartment 8, not the neighbor, he was in apartment 8 upstairs picking up his daughter from the babysitter. He came in, and in the courtroom here, he denied hearing that the police announced themselves or identified themselves as police officers. But you heard a taped statement that he gave to Detective Herman Hall with the Kentucky Attorney General's office early in the investigation, admitting, or not admitting, but stating that he heard the police announce themselves and identify themselves as police. He's backed off of that at this point for some reason, but he heard it. He's an independent witness who verified that the police did identify themselves. So that's the irony of that situation is that had the police gone out there and done a no-knock warrant and just broke in the apartment, nobody would have had an opportunity to get a gun and shoot Sergeant John Mattingly. They would have been taken, in all likelihood, taken by surprise, and this incident never would have occurred. Aaron Sarpay, remember his testimony. He number one, he said police identified themselves as police. He also said that when the entry was made, he was back in the apartment 8, because he and Brett Hankison had a little disagreement about him being outside and him wanting to come out. Brett sent him back in the apartment. He went back in, but he said when they broke into that apartment, it sounded like a machine gun going off. He's an Iraqi war veteran, and he knows what the sound of a machine gun is. He said it sounded like a machine gun going off. And that kind of sets the tone for what Brett Hankison was appreciating at the same time and why Brett did what he did. Aaron Sarpay recovered, as you'll recall, and I don't know if this is has any bearing on this case, but I thought it was somewhat important to discuss, and that is the .223 spent casing that Aaron Sarpay found in the gravel that was between the sidewalk and the patios of these apartments at 3003 Springfield. We heard testimony that an AR-15, that's the type of ammunition that gun uses, that rifle uses. You heard Brett Hankison testify that when he saw the muzzle flash as Kenneth Walker discharged his weapon, or whoever shot the Luger, the 9mm gun that struck John Mattingly, you heard Brett say he thought that he saw in the muzzle flash an AR-15 rifle, person in a rifle stance. Well, Aaron Sarpay recovers a .223 spent casing outside. So what? Not a big deal. Curious, but probably doesn't mean anything. But then later on, we get another report that there's a .223 spent shell casing found in the bedroom in apartment 4 that was apparently missed by the crime scene unit when they methodically and completely searched apartment 4. They didn't find it, but at some point that casing was turned over to the FBI. It was found in the bedroom where the gun that was used to shoot Sergeant Mattingly happened to be found, and where the window was located that Brett Hankison fired 5 rounds through on this night. Now, again, does that mean anything? Is it a coincidence? Well, we heard Bryce Ziegler, the FBI criminalist fellow who did the firearms examination. He said the spent casing found by Aaron Sarpay and the spent casing found in the bedroom in apartment 4 were fired by the same weapon. Now, I don't know if that means anything or not. He didn't have a weapon. There was no weapon found when CSU did their complete and methodical search. But we also know that the family of Breonna Taylor was granted access to that apartment later in the day on March 13th, the same day this incident occurred. Does that mean anything? I don't know. Is it all coincidental? Perhaps, but I have a problem with coincidences sometimes. It just is a bit curious. Another issue that I find a bit curious in this case is that we know that there were 2 occupied apartments that were struck by gunfire, that of Cody Etherton and Chelsea Napper and their son Jaden. We also know that bullets traveled into apartment 8 upstairs where Aaron Sarpe was picking up his child from the babysitter. It's interesting to me, and we know from Michael Van Arsdale, the FBI trajectory expert, we know from him that the bullets that went into apartment 8 did not originate from Brett Hankison just by way of the trajectories. We know they originated from somebody firing at the front door, either Miles Cosgrove or John Mattingly. It's interesting that the only person charged with wanton endangerment for the same conduct is Brett Hankison. Why the Commonwealth chose to charge Brett Hankison with wanton endangerment is a question I've asked myself since the day that an indictment was announced, but nobody else got charged, which was the proper decision, was not to charge anybody, period. I believe, ladies and gentlemen, that Ms. Whaley or Mr. Finke in their closing argument are going to come up and talk about the rules of shooting and how Brett Hankison violated all of those rules. You know, you've heard them over and over again. You have to have a target in sight. You have to know what's in front of, behind, or beside that target. And Brett Hankison didn't do that, is the allegation. You've heard the testimony from Brett. He testified that he saw muzzle flashes at the front door of that apartment. First of all, the apartment was breached, and you have to keep in mind that this entire shooting part of this, from the breach of the door to the end of the shooting, has been described as anywhere from 5 to 15 seconds, I believe. That is fast. The criticism of Brett is that once John Mattingly, his friend, was shot and said, "I'm down," Brett moved away from the fatal funnel that's been described and around the side to the patio to the railing where he had a view of the sliding glass door, and he saw the muzzle flashes inside of the apartment. Now, there's been testimony, I think Jason Vance described the curtains that covered the blinds that were over the bedroom windows and the sliding glass door as blackout curtains. Well, a blackout curtain implies to me that you can't see anything through it. And Brett Hankison said that he saw muzzle flashes. Now, people say, well, he couldn't have seen those muzzle flashes. Well, nobody can say what Brett Hankison saw or didn't see. Only Brett Hankison can tell you that. But you'll have with you in the jury room, Defendant's Exhibit 5. And this is a picture of curtains. These are the curtains that were on the bedroom window. And you'll be able to look at that, and you can see through those. And I would suggest that blackout curtain was not an appropriate description. There were curtains, there's no question about that. But Brett said he could see muzzle flashes through it, and I think this shows that you can at least see them through the bedroom curtains. I mean, this is a good picture to show you can see through the bedroom curtains. And additionally, so the curtains, I think, are one thing. There's also, you'll have photographs that the Commonwealth introduced that show a mirror on the wall in the living room. What do mirrors do? They reflect things, and I would submit to you that potentially that mirror was reflecting muzzle flashes. So I think that the claim that Brett did not see the muzzle flashes is one that is not proven beyond a reasonable doubt by any means. The next thing is that what he said he did is in response to seeing those muzzle flashes, he perceived that his brother officers were being executed in a fatal funnel at the front door. And when he slid around the side to that where that patio is and fired through the sliding glass door, he was firing at those muzzle flashes. That's not a target that is a human. You're not looking at a human being such as I'm looking at you and firing, but he is firing at muzzle flashes, which obviously had to originate from a human being. And he kept his firing inside of the apartment door. He wasn't firing at the officers who were out in the vestibule, because he didn't know they were there. He didn't know that, or he knew they were not inside the apartment. He thought the shooter was still inside the apartment. And when the firing continued, he moved down to the bedroom window and fired through that at the location where he had initially seen the shooter who shot John Mattingly. And you're going to have Michael Van Arsdale's trajectory report back there with you in the jury room when you deliberate. And you can see, and you saw it in here, but you can review it. And the shot pattern is exactly where Brett Hankison intended those to go. Unfortunately, 3 of the shots at the muzzle flashes at the front door went astray into the apartment next door, which we know that Brett Hankison and any of the other officers who were sent out to serve that warrant had no idea existed. It's not obvious when you walk up to the place that there's an apartment right behind Breonna Taylor's apartment, and you heard Miles Cosgrove in his video deposition say an operations plan generally would include information about the layout of the place we're going to, perhaps photographs. None of that occurred. They did not have a diagram. Nobody had any knowledge other than we're going to apartment 4. And I would submit to you that Brett Hankison did not know there was an apartment behind Breonna Taylor's that his bullets could go into. And I would submit that even if he had, he did what he thought he had to do in that instant. And that's what you have to be cognizant of, is this all happened in such a short span. He's a police officer. You know, it makes me think sometimes of when the plane struck the Twin Towers on September 11th. There were pictures of people running away from the smoke and the debris and everything that was coming down. And in those same pictures, there were pictures of police officers and firefighters running toward that danger. That's what emergency personnel are taught to do. They run toward the danger, and that's what Brett Hankison did here. He could have, when he swung out, and there's been some suggestion that perhaps he abandoned his brother officers when he swung away and went around the corner. He could have run straight out to that parking lot and just kept going, but he did not. He ran around the corner and took efforts to save what he thought he was doing was saving his brother officers as they were being shot in that fatal funnel. Ladies and gentlemen, the bottom line is that through all this, the Commonwealth is trying to say that because Brett Hankison took the actions he took, he's a criminal and he deserves to be in prison. I submit that Brett Hankison's the farthest thing from that. You heard how he reacted to try to save his brother officers. You heard everything he did, police-related activities that he engaged in after the shooting was over, including calling the EMS, notifying officers to come for backup, having an officer ram the gate, setting up a perimeter around the building. He's criticized because he didn't go right to PIU. There's nobody that says that that's a mandatory requirement. Chief Conrad said that's protocol, but it's not any kind of mandatory requirement. Brett went there to check on his friend and his brother officer, John Mattingly. He didn't do anything wrong by going to the hospital before he went down to the PIU unit, where he went after he left the hospital, and where several days later he came and provided a voluntary statement as he was requested to do, and as you saw on the screen here. So he's cooperated ever since. He doesn't believe he did anything wrong. Now, having said all that, ladies and gentlemen, the issue is, did Brett do something that was an unreasonable choice in the split second that he had to make a decision of whether he should do anything or do nothing? He chose in that split second to go do what he perceived needed to be done, and that was to save his brother officers. So he simply reacted as I would believe that most police officers would react when danger presented itself. The bottom line is, ladies and gentlemen, you have to be convinced of the truth of the charges here. 3 counts of wanton endangerment beyond a reasonable doubt. And beyond a reasonable doubt is not defined in Kentucky. It's simply it'll be the final 12 of you who are sitting on the jury. It's your collective agreement on what reasonable doubt is. And I would suggest to you that this case is full of reasonable doubt as to whether Brett Hankison committed the offenses of wanton endangerment. Now, the most important part of this whole thing is the instructions the judge just read to you. She read you the instruction of what the statute of wanton endangerment says. And if you read that, it makes some sense, but you can't understand it if you don't understand the definition of wantonly. So on page 3 of those instructions, the term wantonly is defined, just as the Kentucky legislature ordered it to be defined. And if you go through that definition, ladies and gentlemen, I think if you read it all at once, it's a little bit difficult to understand, but if you break it down into segments, you have to look at a person acts wantonly with respect to a result or to a circumstance described by statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that circumstances exist. The testimony in the case, ladies and gentlemen, again, is that Brett Hankison did not know that there was an apartment behind Breonna Taylor's apartment, apartment 4. He didn't know of the existence of apartment 3. And I would suggest to you that in order for him to have consciously disregarded a substantial and unjustifiable risk, he would have to be aware of the existence of that apartment. It doesn't say be aware of or should be aware of. It says be aware of. That means he had to know that apartment was back there, and then he had to consciously disregard the substantial and unjustifiable risk. Well, there's two things there to consider. Number one, if you don't know it exists, how can you consciously or otherwise disregard it? And then number two is, was it unjustifiable? That's you all have to determine. Was it the risk, even if he knew it, was it unjustifiable for him to fire in what he thought was the defense of his brother officers who he thought were being or perceived as being executed in the fatal funnel? As it turns out, they were not. His perception was wrong. But remember, he had to make that split-second decision in that very short period. The next sentence of that wantonly definition says the risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in this situation. Well, was Brett Hankison's returning fire on what he perceived as someone executing his brother officers a gross deviation from the standard of conduct that a reasonable person would exercise? I would submit to you that a reasonable person would do exactly what Brett Hankison did if he sees his one brother officer being shot and perceives that his other brother officers are in the line of fire and being executed. He did what he had to do that day. The fact that his bullets traveled through apartment 4, through the drywall, common wall to apartment 3 is a terrible thing. But it's not criminal, ladies and gentlemen. It's kind of like what you might call it collateral damage. Fortunately, nobody was hurt in apartment 3, just as nobody was hurt up in apartment 8 with the bullets that went up there. But I would submit to you, ladies and gentlemen, if after you consider all this evidence, you have to come to one conclusion, and that is Brett Hankison was doing his duty that night, doing his job. Things went terribly wrong, but his actions were not criminal, and he does not deserve to be sent to prison for what happened on March the 13th, 2020. Thank you, and I would ask you, ladies and gentlemen, please bring back 3 signed not guilty verdicts. Thank you.
All right, ladies and gentlemen, as I told you, we'll take a brief break. So let's break for 10 minutes and we'll resume the trial at 25 till 11. And please don't discuss the case with each other. Thank you.
All rise for the voting jury.
Anything to report from the break, ladies and gentlemen? All right, at this time, we will hear from the Commonwealth and Ms. Whaley.
May I please report? Mr. Smith. Members of the jury, thank you for serving on this jury. Thank you for being willing to sit here for all these days. Thank you for the attention you've given to this evidence. I say thank you, but I also say that being a juror in this country is a privilege. It's a privilege. Not very many people ever get to enjoy that privilege. We have the greatest system of justice in the world. And being a part of it in any form is indeed a privilege. And now is the most important part of your work as a juror, and that is to render a verdict, to deliberate, to decide, to make a verdict, to apply the law that the judge read to you and that you have now, to apply that law, the law of the Commonwealth, to this evidence that you've heard over these days. The law enacted by the legislature decades ago, the law that you all agreed to follow when we questioned you back at the beginning. And I specifically asked if anyone would have a problem following specifically the law of wanton endangerment. And everyone agreed. I also told you when you came back in to be questioned as a group, the Commonwealth has the burden of proof in a criminal case. The burden of proof to prove the defendant is guilty beyond a reasonable doubt, not beyond the shadow of a doubt. And you all agreed that you understood that burden of proof. And we, the Commonwealth, gladly accept that burden. That's as it should be. This is not a case to decide who is at fault for the tragic death of Breonna Taylor. This is not a case about civil rights violations under federal law or the United States Constitution. Whether this defendant or other officers involved violated Breonna Taylor's rights under the United States Constitution in some way, in some obtaining the way the search warrant was obtained, the way it was served, and the fact that she was tragically killed. Should officers go to prison for violating the federal civil rights laws is not your decision. You heard the FBI was given all the evidence in this case from Detective Hall, including the gun you saw that was used by the defendant that night, that was brought in here in an evidence box so the firearms examiners could show you that gun, and then was taken back. And this is not a case about Kenneth Walker. Whether what he did that night was right or wrong, this is not your decision. Under the law of the Commonwealth, you have seen and have in evidence the search warrant signed by a judge in Jefferson County, a valid search warrant, a legal search warrant signed by a judge. This is not about how the case was investigated before that search warrant was obtained. That is not your decision. Because there's one thing that is a fact. There was no search warrant for Cody and Chelsea's apartment. And that's what this case is about. This case is about the actions of Brett Hankison when he shot into the side of that building in the opposite direction from those who were in the line of fire coming out of the apartment. The evidence that you've seen from the Commonwealth and the defendant's testimony is that he is guilty under this law of wanton endangerment of Cody, Chelsea, and 5-year-old Zayden, whose head was on the pillow right in the corner of that bedroom, closest to where the bullets were flying through. He is who this case is about. Five-year-old child. You didn't hear from him, but that's who this case is about. He's one of the 3 victims who had no idea when he went to bed that night on March 12th what was going to happen in the middle of the night. And it's about Cody, also fast asleep that night, thinking it was an ordinary night, sleeping, and then boom, awakened out of a sound sleep, and then fast walking to his door to see what is going on, but couldn't even make it to the door because of the debris flying through the wall. Couldn't even make it to the door. And it's about Chelsea. Now she told you she's a heavy sleeper. But even she woke up, was pulled awake out of that sound sleep by the noise, the boom. And was so terrified when she reached for her phone to call her grandma. Her first instinct, call grandma. And what did she tell you? Her grandma couldn't even understand what she was saying on the phone. That's the kind of trauma she was in. Couldn't even understand what she was saying. And just said, call 911. Call 911. And she did. And you heard not one, but 2 911 calls that Chelsea made. Those calls, and you can ask to hear any of this evidence again. Witness testimony, including the 911 calls, videos, you can ask to see any of that. Those calls were so chilling. The voice and the 911 operator, which of course is they're trained to do, so matter of fact. What is your location? So matter of fact. No kind of comfort. Not the operator's fault, of course, but you can hear the fear in Chelsea's voice. The FBI analyst Mike Van Arsdale showed you what you need to know about these bullets that he shot. In the graphic that he constructed from being there at the scene in June of 2020 when the FBI went in and pulled bullets out of the walls which hadn't previously been retrieved. When PIU was there that night, they collected everything that was laying there, all the casings, all the bullets in the apartment that had been shot. From the door, a few of the bullets that had been shot by the defendant in the opposite direction from those who were in the line of fire. And this graphic reconstruction tells you everything you need to know about where he shot compared to those who were in danger, compared to those who were in the line of fire, in the doorway, when the one bullet was shot out the doorway that was found in the breezeway. One bullet, not an AR. One casing from that 9mm found in the hallway. One bullet found in the breezeway. One 9mm found under the bed. You heard from Mike Nobles, the detective who had the ram. Walking up as they were entering, he couldn't see in those sliding doors. There's vertical blinds and there's curtains, drapes, full length. And you'll see in the photos, you saw already in the photos. He couldn't see into those. Nobles is the one who had the ram. Nobles told you he was distracted as he was standing there in the doorway as they were knocking, distracted by Hankison arguing with Mr. Sarpe upstairs. I think all the detectives who you heard talked about this distraction caused by the defendant arguing with Mr. Sarpe. Detective Nobles testified he never saw Hankison in the doorway. He said Hankison was by the steps. That's where he was, at the end of the steps. That's why he could see Sarpe up there, Mr. Sarpe, and was continuing to be confrontational with Sarpe. Detective Nobles told you Miles Cosgrove was the one standing over John Mattingly, returning fire after Mattingly was shot. Tony James told you as he was approaching down the sidewalk, he couldn't see through those sliding glass doors. He was the one with the ballistic shield. He took a position over by the wall right next to the door that says number 3 on it. There is no way any one of those officers who walked up to that breezeway could have failed to see 4 doors in that breezeway where you all went. 1, 2, 3, and 4. Or could have failed to see upstairs. Mr. Sarpe walked out of apartment 8. A door right next to 8, 7. A door right next to 7, 6. A door over to the left, 5. In the same configuration as the first floor. Now, I'll talk a little bit more about that in a few minutes. Tony James told you he also heard the defendant engaging with Mr. Sarpe. And Tony James testified they were very loud about this argument going on. And Tony James told you he did not shoot. Now, unlike Detective Nobles, who had the ram and didn't have his gun at the ready, Tony James did. But when the shooting began, he was engaged in getting out of the line of fire and getting out of there. And seeing what could be done to help Mattingly. He did not shoot. He did the right thing. You didn't hear anything about Mike Campbell shooting either. Mike Campbell was at the rear, at the back corner to the left as you're facing the breezeway. Mike Campbell testified that he saw Sergeant Mattingly return fire after the shot came out of the apartment, after the door was breached. He saw Mattingly return fire. Now, Mike Campbell had a good perspective back there, and he could see. He testified he saw Sergeant Mattingly return fire, and he saw Detective Cosgrove return fire through the doorway. He testified he did not see where Hankison was, and he had no idea what he was doing. Mike Campbell also testified Mike, did not shoot. Obviously, Mike Campbell and Tony James were in emotional reaction, trauma, when they realized there was a shot been fired out that door and hit Mattingly. They didn't wantonly just start shooting in revenge. They didn't start shooting in revenge. Well, our fellow officer was shot, so we need to shoot back. No. Mike Campbell got out of there and started doing what he could to help Mattingly. He did not shoot. Miles Cosgrove, who you heard from his deposition, also said Hankison was arguing with Mr. Sarpe, and he used the words yelling. Hankison was yelling at him. Miles Cosgrove realized no one was behind Nobles, who had the ram to cover Nobles, because Nobles didn't have a gun. He had the ram, or he didn't have his gun drawn. So Cosgrove moved up. Once the ram starts the first hit, Cosgrove moves up to cover Nobles. That's why he was in the threshold, in the line of fire. After Noble's breaches, Noble spins out of the way to the right. You saw the ram laying on the ground there to the right of the door. So that's where Cosgrove is when the door is open. He was in the threshold after Nobles spun around. Cosgrove said he saw the figure in front of him and he saw the gunshot fired at him, and he fired back. You know from the round counts that were done at Public Integrity Unit, where all of the officers guns were taken down there and unloaded with the magazines unloaded. That's called the round count, how many rounds were missing. So it could be determined how many shots were fired by each one of the three who shot. Mattingly fired 6 shots. There were 6 rounds unaccounted for in his round count. Cosgrove fired 16 shots in the doorway. Mattingly, 16 shots from the doorway. Lieutenant Lacefield, the firearms instructor commander, told you, when asked, how long does it take with this Glock 40 caliber Model 22, the service weapon, the one you saw, how long does it take to shoot all of the 16 rounds in that gun, which it can hold if it's fully loaded with one in the chamber? And he said 4 to 5 seconds. 4 to 5 seconds. Cosgrove said he did not realize he had shot 16, but all of his shots are here in the doorway after the shot came out and hit Mattingly. He was in the line of fire. Hankison's round count, 10 rounds missing. And all his casings are accounted for. All his casings are accounted for out here in the parking lot, 10 of them. All these casings that you'll see in the photo in the breezeway were identified by the Kentucky State Police firearms examiner Stephen Hughes as having been fired from Cosgrove and Mattingly's guns, because that's where they were, in the doorway, responding to incoming shot from the hallway. One shot, one bullet, which went through Mattingly's leg and was found over by apartment 1 door. I know you all have heard the old saying, a picture is worth 1,000 words. So, nothing can take us there to actually witness what happened. But I want to go back over some of these photos to refresh your memory of some of the testimony. This is the overhead of the complex that you saw. Now, I want you to pay attention to when the defendant was on the witness stand, I asked him with this photo to show how he drove in that night and where he parked. And the main road out here, I guess St. Andrew's Church Road or St. Anthony Church Road, out here, and then you come up this way and turn to the left and come down, because you can't get in this way, or couldn't on March 12th because of the gate here. So you come up this way, turn in to the left to this road, and drive through here and around, and this is the dumpster, and that is where, in this area, is where Hankison said he parked. Some of the other vehicles were parked in this area as well, except the white van, of course, the van that the Sequoia that Mr. Sarpe was driving was here, parked perpendicular to those, and then I believe the white SUV that Mattingly was driving, you heard, was right behind the Sequoia. But here's the important thing. When you drive in this way, it is obvious that this is a complex of apartment buildings. You drive through here and you are seeing the patio and the balcony of this two-story building. The two patios, this is only an 8-plex right here. These other three, and this one also, are 16-plex buildings. So that you have, in this one, you have 4 apartments on the first floor, 2 at the front and 2 at the front and 2 at the back. And then on the second floor, you have 4 more, 2 at the back and 2 at the front. So that you have 2 patios and 2 balconies. And then in the front, the same thing, 2 patios and 2 balconies. But in the 16-plex buildings, you have 2 on this side of the building, 2 patios, 2 balconies, and on this side, 2 patios, 2 balconies. Patios downstairs, balconies upstairs. And the same at the front. So that it's obvious as you are driving around these buildings that you see, oh, here's 2 balconies and 2 patios on this side. And over in the front, the same thing, 2 patios and 2 balconies. Same thing with the 16-plex, which this is the building, 3003, and here's number 4 right here. Before you can even get to 4, as you're walking down the sidewalk or the parking lot, you have to pass this set, which is identical to these across the street, that you have already passed as you're driving through and seen, oh, there's balconies and patios in back of these buildings. Oh, here's the front. There are patios and balconies in front. So if you're a trained observer, say for instance, a police officer, a 20-year veteran police officer trained to observe your surroundings for 20 years, you're going to take note of the surroundings as you drive in and approach the target destination, which is apartment 4. These buildings are identical. So this is the back of 3003, and right here is Cody and Chelsea's patio and railing there, just like the one in the front. No, you can't see it from the front, but you can see the doors. You can see apartment 3 door with a big 3 on it within 3 feet. You all were there. Within 3 feet of apartment 4 is the door right there with a big 3 on it. But you've already seen these buildings driving in. Oh, there's patios at the back, identical to these. Next photo. And here we have the breezeway. And actually, even in this photo, it looks larger than it is. In reality, it's just makes it look larger than it is. But you see how close these two doors, this is apartment 2, and then directly across, this is apartment 4, of course, directly across here was the door to apartment 1. There is no way that he didn't know. There's another apartment right here. Next photo. Another photo of the breezeway, and now we can see apartment 1 door, 2, 3, and here's 4. And this was taken, and you heard Lieutenant Vance testify about the Sergeant Vance, I think. Markers. These all represent casings collected. All the .40 caliber casings from the guns of Mattingly and Cosgrove, because that's where they were when they shot from the line of fire. And here, marker 37 is the bullet that was collected, that was identified by the FBI firearms examiner Bryce Ziegler, this bullet here, as having been fired from the 9mm found under the bed in the south bedroom of apartment 4. The bullet that went through Mattingly's leg and ended up right here. The rest of these markers are all casings that were ejected by the guns of Mattingly and Cosgrove, because they were the ones in the line of fire, not this defendant. He was over here shooting wildly through sliding glass doors covered with vertical blinds and drapes. Now, in the daylight the next day, when that picture counsel showed you of the bedroom window with the black drape, that was taken the next day in the daylight. And he wanted you to see or believe that you could see through it, because by now it has bullet holes in it. And it's daylight, so yes, you can see daylight through the bullet holes the next day. But not that night. Next photo. These markers are the defendant's casings. Every one of these, 5, 6, 7, 8, 9 is under the tire, 10. Here is the sliding door with the bullet holes in it, and the window with 5 bullet holes. 5 bullet holes in the sliding door and 5 bullet holes in the window. And here's the casings. These up here in the gravel were testified about by Sergeant Vance that were weathered casings, and you may have noticed some when you were out there that were laying and had been there a while. So these up here in the gravel were not relevant. These all in the parking lot were identified by Kentucky State Police Examiner Stephen Hughes as having been fired from the defendant's service weapon. Every one of these casings was a positive identification by Stephen Hughes with Hankison's .40 caliber Glock. Next slide. And here's two more. This is not a casing. This was a magazine that was dropped. 1 and 3, marker 1 and 3, are two more of Hankison's casings, both identified as positively having been fired from his service weapon. Next slide. Again, 1, 3, and now you can see marker 4 between the two vehicles in the parking lot, another casing that was positively identified as having been fired from Hankison's gun. Next slide. Close-up of the sliding doors. Now, obviously, we can see through them now because the curtains are pulled back, the blinds have been pulled back so that they can see the bullet hole, the bullet defect. 1, 2, 3, 4, 5. Shattered glass. Next. Now this, we're going to follow the pattern of those 5 bullet holes we just saw. So this is taken from the inside, of course, and they have pulled the curtains back, and you can see the bullet defects in those. Here you can see some of the blinds that had been broken down during the shooting. And you can see shattered glass here, but some of the vertical blinds that are now laying on the floor. Next. Now, the bullets have been shot through the sliding glass doors, and here is where they went through the wall that's straight ahead, looking through the sliding doors. This wall is straight ahead. So this is the common wall with apartment 3. And we have one defect here, which this bullet is the one that ended up falling down and was laying on the carpet. So that's that one there that was collected. And later identified by FBI examiner Ziegler, and he described it as a bullet jacket that was found here. It didn't make it through, and he identified it positively as having been fired from Hankison's gun. So that's one. And then we have 2, 3, 4 bullet holes here. Next slide. And now we can see the 5th one. First one was the chair. Now we can see 2, 3, 4, 5 holes going into the wall. And next. And now we can see the trajectory rods that examiner Van Arsdale, who created the graphic, during his work, he was measuring from the entry hole into this wall through to the drywall of apartment 3, where he could still see, even though the drywall had been repaired in apartment 3, he could still see where the hole had been in order to make this trajectory. These are the 2 clock defects right here, which you'll see on the other side. And then you'll see this one. This hole here is one that the bullet ended up in the stud. So this is the stud, and the bullet was pulled out of the stud by the FBI, and it was identified by firearms examiner Ziegler as having been positively fired from the defendant Hankison's gun. This one. These 3, this one, these are the 2 clock ones you'll see, and then this is the one that went straight through to the chair rail or bumper on the other side of the wall. Next. So now this is apartment 3, where they have come through the bullets. It's a mirror image of the other wall. So here's the clock, defect here, or bullet coming through here, bullet coming through here. And then the third one be the next slide. Third. So there's the chair rail in apartment 3 that mirrors the entry hole on apartment 4, and here's the exit on apartment 3. Now we'll see where this bullet, and there's this bullet, ends up on the dining room table of apartment 3 that came through over the chair rail. Next slide. Now, the second bullet that was found that came through one of the bullets came through the clock, we'll see in the next photo, hit up here and then dropped down on this carpet. Next slide. So here is the bullet. One of the bullets that came through the clock and then hit up above the sliding doors and then dropped down on the carpet. That's the second bullet they retrieved from apartment 3. Next slide. And here is the hole in the vertical blind where one of the bullets that went through the clock kept on going, and that's where the one that probably almost hit Cody as he was walking through, it went all the way through the blind and shattered the sliding glass door. This other bullet from the clock ends up here, doesn't make it through, and falls back down on the carpet. Well, this is the one that shattered that door and left then it wide open with shattered glass everywhere. Next slide. The window bullets. This is the 5 window bullets. 1, 2, 3, 4. 1, 2, 3, 4, 5. You can see here, this of course is taken in daylight the next day. You can see these are the horizontal blinds. Now you see how close those blinds are together? Well, those were down. There's defects in them now. And covered by the black curtain on the other side. Next photo. And here's the other side where those bullets came through. Fired from here on the graphic. So 5 bullets were fired at that window. One of them you heard about was found, it came through and hit this dresser drawer and then ended up inside the dresser drawer. That's one. And the next. 2 more hit this wall as you're facing the window. It'd be the wall to the right. And there's the defects. And those 2 were later found in the wall by the FBI in the search in June. Those 2 were pulled out and they were tested by Bryce Ziegler and found to be a positive identification to Hankison's gun. These 2 bullets here pulled out of the wall. So that's 3 bullets so far from the window that were retrieved. Next slide. So here's the 4th one. This went into the utility closet in the hallway here. And there it is, the bullet right there. That was retrieved, and that was positively identified as having been fired from Hankison's gun. That one was retrieved during the crime scene unit search, and that one was identified by the state police as having been fired from the gun of Hankison. Next slide. And this is the 5th bullet through the window that was found in the soap dish. That obviously you don't see any defect behind it, but must have ricocheted from somewhere in here. And here it is, right there. The fifth bullet through the window. So we accounted for all 5 in the sliding door because we had the one that hit the chair and fell on the floor. That's 1. One that got stuck in the stud that was pulled out later, that's 2. And then 3 of the ones fired through the sliding door that went all the way into apartment 3. Those are the 3 important ones. Because any one of those 3, 2 that went through the clock, especially those 2, that went through the clock and then through the clock in apartment 3, and 1 all the way out the sliding door, could have any one of those. In fact, any one of the 3, even the one that went through the chair rail and ended up on the dining room table in apartment 3, could have taken another deflection. You know, who knows where it could have deflected out of that clock. Instead of going through the sliding door in there, could have gone into that bedroom where little Zayden had his head on the pillow. Next. And here is the 9mm that was found under the bed in apartment 4. Right here is the south bedroom, found under the bed. That was collected, tested by both the Kentucky State Police, the Kentucky State Police examiner, Mr. Hughes, made a positive identification of the casing found in the hallway. The casing found in the hallway was fired from this 9mm. 1 casing. 1 bullet was found in the breezeway, marker 37, that the FBI examiner, Mr. Ziegler, positively identified as having been fired from this 9mm. Next. Now we're back out to the front. And we see, again, the defects, the shattered glass, the railing up, or the balcony up here. Apartment 876. There's the Christmas tree that Cody Etherton told you they had set out in this bin, and that's where it ended up. Of the you can see the relationship between the sliding door and the window. You definitely have to change position to start shooting, stop shooting from this sliding door and start shooting through the window. It wasn't all just one action. There had to be a position change. The continuing shooting blindly into the side of this building. There were no AR bullets found anywhere. Anywhere. There were no bullet defects in apartment 4. If this person was standing here with an AR shooting out, where are these defects? Who got shot with an AR? You didn't hear any testimony that any of these officers, including Mattingly, who did get shot, but who got shot with a 9mm, one bullet. Who came in and said they were shot with an AR? There was, Cosgrove was right there. Where's the bullet defects of all this AR shooting going on? And there was no bullet defects in these walls. There were no bullet defects bullet defects of exiting anywhere of an AR. There were bullet defects coming in from Mattingly and Cosgrove that went in to these walls that were fired from out here. Yeah. The reason there were no AR bullets and no AR bullet holes and nobody that got shot with an AR is because there was never one. When Lieutenant Vance interviewed the defendant, he couldn't remember which way the door opened. When Lieutenant Vance asked him in that interview, which way did that door open? He couldn't remember. It's in his statement. Which way did the door open? And he responded, I can't remember. That's because he was never in the doorway. The only ones who had ARs or long rifles in that night, the only ones were the patrol officers that he called out and told, we need long rifles, we need long rifles. So you know what that did? You know what that did when they all showed up with long rifles, the patrol, all out behind that first slide that shows the overhead of the complex. And you saw on the body camera of one of the patrol officers with the long rifle pointed at Cody, and he testified he was standing there with his hands out the window of what used to be the sliding door, and they were pointing rifles at him, and there was a dog back there barking. He was afraid it was going to lunge at him. That put him at even more risk of serious physical injury or death caused by this defendant telling them to come out with long rifles. Now, I want to look at the instructions. There they were. Back here with the long rifles pointed at Cody. Instruction number 4, all the wanton endangerment ones are the same. That in this county on or about March 13th, for the finding of the indictment, he discharged bullets from a handgun into apartment 4 that entered apartment 3, which was occupied by Cody Etherton. Now, this doesn't require, nowhere in this instruction are you going to find anything that says, that asks you to find that he knew that Cody Etherton, per se, was in that apartment, obviously. You are not required to find that he knew there was a man named Cody Etherton in that apartment. If that was the case, this would be an intentional crime, not a wanton endangerment. It would be some sort of intentional. B, that he thereby wantonly created a substantial danger of death or serious physical injury to Cody Etherton. That under the circumstances, such conduct manifested extreme indifference to the value of human life. Now, what, and you have a definition of wantonly, but I want to look at let's look at how the evidence has proven this. First, the instruction says he wantonly created a substantial danger of death or serious physical injury and this would be to Cody, to Chelsea, and to Zayden for each count, and that under such circumstances, such conduct manifested extreme indifference to the value of human life. So how is the evidence established this? Go on to the next. So wantonly. The definition of wantonly states a person acts wantonly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstances exist. And this risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe. So, you have to find that he was aware of the risk of shooting blindly into this building. There's the building. Well, there's where the bullets went through, but the building, the side of the building, the front of the building, where there was no view, through the sliding glass doors and the window. That wantonly, he has to be aware of the risk. And how do we know he's aware of the risk of shooting blindly? Well, because he has 20 years of training as a police officer. He has 20 years of twice a year having to go to the range and sit through not only classroom instruction and simulators, but actual firing at the range, shooting at a silhouette target. Because that's where you're going to be using defensive force, deadly defensive force, is against a person who's a threat. So that's why they have silhouettes shaped like a human body. And he couldn't even tell you that after Officer Gelhausen explained, yes, we use the silhouette as the target in these exercises out on the range. And we call it LMPD blue because it's a blue color. So 20 years of training, he's aware of the risk of shooting when you don't have a target. And he consciously disregarded. He ignored that risk. He consciously disregarded it. And he shot wildly in the wrong direction. And a threat can be a muzzle flash. What did Officer Gelhausen tell you about that? Seeing a muzzle flash. It can be a threat, but it has to rise to the level of an active threat. It can't just be a threat. A threat is not something that requires that you shoot at it. It has to become an active threat. There has to be a person at the end with a gun that caused that muzzle flash. It has to be an active threat. Officer Gelhausen said, if a person is standing there and you can see they've got a gun even down to their side, that's a threat, but it's not an active threat. You don't have a right to shoot somebody who's just standing there with a gun down to their side. And he told you. Now, if they raise it and point it at you, then you do have a right. That's an active threat. So he was aware of the risk of shooting blindly, and he disregarded that risk and shot wildly in the wrong direction. Next. He created a substantial danger of death or serious physical injury. Cody Etherton was at absolute risk of substantial danger of death or serious physical injury. And serious physical injury is defined for you. It's very straightforward. Chelsea was in substantial danger when those bullets came through. They could have deflected instead of hitting that clock and going straight through to the sliding door. Any one of those 3 bullets could have deflected off that clock and gone to Chelsea's bed. Or even as she stood up. Any one of those 3 bullets could have hit little Zayden in that bed closest to the line of fire where they did come through and go out the sliding deck. A little deviation in degree and angle of those bullets as they came through this wall and through that clock, and any deviation in the angle as they deflected could have hit. 3 bullets came through. Any one of those 3 could have hit Cody, Chelsea, or little Zayden. Next slide. The circumstances. So, the instructions states that he wantonly created substantial danger of death or serious physical injury, that under the circumstances, such conduct manifested extreme indifference to the value of human life. So what are the circumstances? Okay, the circumstances under which he fired wantonly. Well, you have a 16-plex building, as I went through with that overhead, and you're driving through there, you can obviously see all these apartment buildings, and you drive right past 2 of them. You drive right past the ones that you're at the back, and you see, 1, 2, 3, 4, 5, 6, and then you drive around and you see, here's the front, and 8 more in the front, 8 in the back, 8 in the front. More circumstances. Testimony from the defendant himself. I told him, this is him telling Mr. Sarpy, I told him to go back in numerous times. His focus, when everybody else was focused on that door, on the knocking, on trying to get a response so they could peacefully serve the search warrant. When everybody else is focused on the job at hand, he is talking and arguing with Mr. Sarpy upstairs, taking the focus off. Mike Nobles, the one with the ram who's got the most important job at that time. Mike Nobles, the most important job, he's the one with the ram, and then they said, go ahead. He didn't want to have to use that ram. Mike Nobles, this distracted us, the argument with Sarpy, took our focus off the door. More circumstances, next slide. He's the one that directed the patrol to bring long rifles. Cody was in more danger with rifles in the back. More circumstances. His wild shooting with no target, with no reason, put fellow officers in jeopardy. His shooting from this sliding door, while they're still here in the fatal funnel, he was never in the fatal funnel, ladies and gentlemen. He was out here. His shooting wildly through this sliding door put his own fellow officers at risk. Look at this angle. They're still in the fatal funnel. Circumstances, the doors in the breezeway are clearly visible. a trained officer, trained 20 years to observe his surroundings, especially in a situation like this. What you won't find in the instructions is anything that requires you to find a motive. You're not required to find or know why he did this. You won't find that in there. You won't find anything in the instructions requiring you to find or consider whether he acted in self-defense or whether he acted in defense of another. You won't find that in the instructions because that, once again, would have required an intentional shooting. That may be something that would have been applicable to those that were in the fatal funnel who did shoot back intentionally. You won't find in these instructions anything that requires you to decide why he did this. And the facts are, he actually came in here and told you that he was standing on the doormat and saw the flash straight ahead in the hallway, and then when the hallway lit up, he saw a figure in a tactical stance with a long rifle. He actually came in here and told you that he was the one standing in the doorway and saw the shooter. Okay, well, the fact is that didn't happen. Because if he had been there, he would have shot then with a real active threat in front of him. Like you heard Mattingly and Cosgrove, who were the ones there, who were in the fatal funnel, who did take fire, who did take a bullet and fired back. If he had been the one standing there instead of Mattingly and Cosgrove, yeah, we wouldn't be here. It may be in another situation, but it wouldn't be. He may be in another situation, but we wouldn't be here. He was never in the line of fire. You do not have to find why he did this. Next slide. His wanton conduct could have multiplied one tragic death, Breonna Taylor. His wanton conduct could have multiplied her death by 3. Easily. This is what this case is about. This is who it's about. By grace, they're still alive. I ask that you find, based on this evidence, that this defendant is guilty of wanton endangerment under the law of Kentucky for his conduct that night. Wanton endangerment of Cody, of Chelsea, and Zayden. Thank you.
All right, ladies and gentlemen, we are very glad to still have all 15 of you with us, but only 12 by law are able to deliberate this case. So we'll randomly draw out 3 of your number, and I will call those out. When you hear your number called, just please remain seated. Juror 289-5941, Juror 289-6551, Juror 289-5881. Do you solemnly swear to keep the jury together, to allow no one to discuss the case with them, and to not do so yourself?
I will.
All right, thank you. All right, for the three of you whose number I called, could you just raise your hands, the three that I called your number? All right, if the three of you will just remain seated, and then we'll let the other 12 of you go back to the jury room to begin your deliberations. You are released from the admonition that you're not to discuss the case with each other. Please discuss the case with each other fully. As I said, we'll send the exhibits and the original of the instructions back to you in just a few minutes. I believe your lunch is either here or on its way.
Is here. If you want to have your lunch, the three that remains here, just wait and I'll bring them to you.
All rise for the departing jury.
To the three of you whose number was chosen, you may feel some relief, you may feel some disappointment. You've sat through this trial and you've been extremely attentive, taken lots of notes. But we do all appreciate so very much the time and attention that you have paid to this case. You have helped us get through this. We're in a pandemic, and yet all 15 of you were able to be here each and every day, and we certainly are relieved for that. You are also relieved of the obligation to not speak about the case. You may want to talk with the attorneys, you may not. It might be helpful to them to hear from you, but if you wish not to speak with the attorneys or the media or anyone else, you are certainly not required to, and they will understand. As Anthony said, we do have your lunches for you. If you prefer to be escorted out by Anthony, he will be happy to do that for you. So if you will, just remain seated. I'm going to release everyone now so that they can leave the courtroom, and we will get your lunches for you. Thank you again. All right, we will be in recess until we hear back from the jury. Counsel, if you would leave me your phone numbers so that I can reach you if you're not going to be staying in the building.
10:30. 10:30. Officer down. 10:30. Officer Sean Springfield.
What's the location?
Officer Sean Springfield. 10:30. I see EMS. EMS is around the corner. Radio. We need EMS fucking up here now.
I'm getting him started.
Already down the street. Tell him to get up here.
Right, okay, use the to Springfield Drive. We have EMS on the way.
1 David on Springfield. Where y'all at?
3007 Springfield Drive.
Do not block EMS. Ram that gate. Ram that gate, patrol car. Ram that gate. Patrol, ram that fucking gate now. Ram it with your car. Ram it.
Here, quick cut. Here. We're gonna cut him. Here. Cut it with my knife. You okay, John? John, you okay? Huh? Yeah. Fuck this EMS, dude. It's 30 minutes away. Somebody give me the radio with SWAT on it. SWAT 1. Here.
Officers encountered rifle fire. Officer down. Bring long guns. Subject is still inside. Radio barricaded with a long rifle. Looks like an AR.
Subject still inside, barricaded with an AR.
Be advised.
He is still inside. We've got cover on the door. We don't know if there's a back door to this place.
Looks like an upstairs apartment. Upstairs apartment. Text your family. Hey, upstairs apartment. You want me getting a turret? Cover high? Yes. What'd you say, Sarge? Text your family. And upstairs
I think it's an upstairs apartment.
They all pulled up and we gave you the fucking turret. Now what if it's like, okay.
Person apartment number 4. Building 303. Apartment number 4. Please come out with your hands up. You have to talk loud. I cannot hear you. Keep your fucking hands up. Coming out. Step to your right. 2 steps. To your right. 2 steps. Now step down on the step and keep walking backwards. Step down, and I want you to walk between these cars. Walk straight down the steps or backwards. Keep walking backwards. 1 more step, sir. Now I need you to walk back between these 2 vehicles. Keep walking backwards. You're almost doing it. You're doing a great job. Yeah. Keep walking. Do not do anything else. Do not reach down. We'll get him right here. 20, right here. Keep coming back, sir. Keep coming back, sir. Keep walking backward. You're scared. Right.
walk straight back, or I'll send this dog on you. Walk back to my boy. Walk back, or I'll send this dog. Walk back to me. Keep on walking. Walk down. Walk. Walk back to me.
Let's get behind this car for cover.
What did I do?
Who else is in the apartment?
Nobody. My girlfriend's dead.
Tell them we have 1-10-15.
What? I don't know.
Inside?
Yeah, somebody. I was banging at the door and she said, who is it? And I just started shooting.
No, we down 3 times, 3 searches.
This pocket's clear. There's somebody in there dead?
Yeah, my girlfriend. It's her house. It was her house.
Who was shooting at us?
We have to go in if there's somebody.
What is this about?
I'm with you if you want to go.
We're both just regular worker people.
Where is she at in the apartment?
She's on the ground.
Where at?
In the hallway.
What kind of gun did she shoot?
It's a regular 9mm.
Did she shoot or you shoot it?
It was her. She was scared. We didn't even know who it was. We didn't know who it was. We was in the bed.
Got you.
We was in the bed. We didn't know who it was. The gun's legal, like, and everything. We don't even know who it was.
I don't know who it is.
We asked 10 times.
We don't know whose it is.
Door.
Yes.
Here comes the fence. Yeah, hey, heads up, man. Stay back a little bit. Is Joe good? Everybody okay? Yeah. You all right, Joe? Watch out. Watch the door. Watch the door. Front door. Hey, I'm throwing to the front door.
Hey, you're not gonna get over that lip. We're gonna have to go up there.
All right, that's fine. Give him one.
One on me.
Get yours over to your right.
What do you need, Hogan?
Cover her. Oh, sorry. Give me another body.
I'm here.
Hold on. We're gonna stay here, Zoo. Go with Sarge and clear that room to the right. And he's focused.
One on me.
I got you.
Hold on. I got her.
One on me.
I'm here.
I got him.
Fighting this door too.
Hang on.
Hey, Mark. Yeah. Can you cover her?
Hang on a second. Baker, out of that room.
I'm good right now. Good.
Cover from the other side. We got a bathroom that sucks back.
Hold on, Mike. All right.
Closet immediately left.
You've got two closets that folding doors.
All right.
To your left and an open bathroom. Looks to be mostly clear. I'm up. I'm down here.
Oh, I can see he's clear. Hogan.
Yep. Clear?
You ready?
Yeah. Let's get this bed real quick. Let's look in our bed real quick.
Hang on, let's check the bed.
Yo, hey, man. Have them pop that door. Is anybody right there to your left? No. I'll come to it.
We still got to check the bed.
Check her. We gotta check her. Check her. Make sure she's good.
Hey, lift the bed up. I'm going to go this way with my pistol or rifle.
Yeah, go ahead and give me a message here.
Clear.
You can roll her over. Joe. There you go, buddy. Ma'am, can you hear us? Louisville Metro Police Department. Check that wrist, dude. Check the wrist. Medic up! Scene secure. She's 1080. We're leaving a couple people in here to hold the scene. It's secure for detectives to come up. So I think it's casing right there. Sorry. Right there. You're all casings. They're casing. So,
Oh, that's their gun. Right here.
yeah, right there.
That's theirs.
No, that's ours. It looks like theirs is in there. But I'd back out until they get PIU in here. So.
Especially if there are any guns visible.
We did not see any.
Take long enough. Is there any windows that go out that way?
The only casings look like 9 mils.
He said she was shooting. The suspect said that his girlfriend was shooting the ass with a 9mm.
Hey, this room right here, there's a pistol underneath the bed.
I'm not worried about that right now.
No, I know.
You know what I mean?
So, let it get out.
It's a crime scene.
That's it, let it get out.
Do not walk by yourself. This is our city. This is our town.
For months in Kentucky, residents outraged by the killing of Breonna Taylor campaigned for the police officers who shot her to face charges.
Commonwealth of Kentucky versus Brett Hankison.
In September, a grand jury investigation indicted one officer for shooting into a neighbouring apartment and no one for killing Taylor.
Is that the decision of the grand jury? I will grant the motion and assign bond in the amount of $15,000 full cash and issue a warrant.
Is that it? Is that the only charge? It can't be good. It can't be good.
No one has been held accountable. This is injustice, and this is a start clock for the next level of our protest.
What happened in the final minutes of Breonna Taylor's life? A full telling of that story has been impeded because none of the 7 police officers who raided her apartment used body cameras, a violation of police policy. But with the recent release of thousands of documents and images collected during 3 investigations, the Times initiated a fresh examination of the case. We used crime scene photos to create a precise model of Taylor's apartment. We forensically mapped out and retraced the first bullet fired by Taylor's boyfriend and the 32 bullets that police shot in return, through windows, walls and ceilings. Using interviews officers gave to investigators, we charted their movements as they carried out the raid. And we analysed hours of 911 calls, grand jury proceedings and footage by the SWAT team that arrived after the shooting.
Man, can you hear us?
Members of the grand jury have accused Kentucky's Attorney General, Daniel Cameron, of shielding the officers involved from homicide charges.
Our investigation found that Mattingly and Cosgrove were justified in their use of force.
Boom, 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 boom.
Sergeant Mattingly may have been justified in returning fire when he's fired upon, but our new analysis paints a more complicated picture about how this raid was compromised from beginning to end. We'll outline the flawed intelligence and tactical mistakes of a hodgepodge team of officers, their failure to properly announce their presence at Taylor's, the chaos and excessive use of force that ensued.
Okay, there's another hole right below the clock.
And we'll explore the damning analysis of an experienced SWAT commander who was called to the scene after the shooting.
We just got the feeling that night that something really bad happened.
The focus of the police investigation on March 13th is not Taylor's apartment, but properties 10 miles away in West Louisville.
Local Metro Police.
Hands behind your back, boss.
We're executing a search warrant. Come out.
Where dozens of SWAT and police officers arrest an ex-boyfriend of Taylor's and his associates and seize evidence including drugs. These officers are wearing their body cameras and they carry out the raid safely and without incident. What the SWAT team doesn't know is that at this time, a hastily assembled team of narcotics officers is about to raid Taylor's home across town. They suspect her ex-boyfriend keeps cash or drugs there, but their intel is poor. They don't know she has a new boyfriend and they think she lives alone. When 7 officers begin the raid at 12:40 a.m, they notice the lights are off, except for the flicker of a TV in a bedroom.
The light on the bedroom, the TV. I remember seeing it lit up blue, or when we pulled up.
Suggesting they know where Taylor is. In less than 3 minutes, she would be fatally shot. Inside, Taylor had dozed off while watching a movie with her boyfriend, Kenneth Walker. Adjacent is the bedroom of Taylor's sister, but she's not home. A hallway from the bedrooms leads to a living area, and the apartment's entrance is in this breezeway. The only light is this lamp opposite her door, where now the police begin to stack. In this reconstruction, we hear the official testimonies given by the 2 officers nearest the door, Mattingly and Nobles, Cosgrove, who's providing cover, and Hoover and Hankinson beside them. And we'll hear from neighbours and Kenneth Walker, who was interviewed by police right after the shooting.
When we all got up in line, I knocked on the door, banged on it.
Just as Mattingly begins to knock, a man emerges from the apartment directly above. He doesn't live there, but is picking up his child after finishing work.
The door right there, that's why the babysitter live. So I came to pick up my little girl.
A squabble with Detective Brett Hankison ensues, and already the team seems on edge.
I remember Brett extending his gun saying, "Get back in your apartment, get back in your apartment." Brett was a little bit worked up. I remember looking at Brett saying, "Brett, relax. Brett, just relax, relax."
The man retreats inside. The police are supposed to be conducting a knock and announce raid, but that's not what Mattingly says happens at first.
We didn't announce the first couple because our intent was to give her plenty of time to come to the door.
Inside, Taylor wakes up.
So it's a loud bang at the door. She pops up out of her sleep. It scared her to death. Me too. Like, who is that?
Banged on the door. no response. Banged on it again, no response. At that point, we started announcing ourselves.
Whether the police announced themselves clearly enough is a critical issue in this story that we'll return to later on. Not knowing who's at the door this late, Walker grabs his licensed handgun.
Another knock at the door. She's like, "Who is it?" Loud at the top of her lungs. No response. So I'm like, what the heck?
They rush to get dressed and walk toward the door.
Never even made it like mid-hallway. But as loud as we were screaming to say who it is, I know whoever would be on the other side of the door could hear us.
Outside, some of the police do hear Taylor.
I can hear somebody inside. I kept telling John, I can hear her.
But after knocking and waiting for around 45 seconds, they decided they've given her enough time to respond and rammed the door open.
The last time, I just said, let's just hit it. And that's when we did the, police search warrant.
We'll show here what the police and Walker describe seeing next.
And I hit it. After the third hit, it flew open. And that's when it hit the fan.
As we're coming to the door like comes off the hinges like an explosion.
The officers now make a tactical mistake. Mattingly steps into the doorway and puts himself in what police describe as the fatal funnel, a position vulnerable to gunfire and hard to move from.
I could see down the hallway, and there's the male and a female, side by side, shoulder to shoulder, almost like they were together.
The apartment is lit only by the breezeway light that's coming from behind Mattingly and the faint glare of the TV in Taylor's bedroom.
You can't see anybody, though. It was dark. There was no lights.
Thinking it's an intruder, Walker aims low, shoots once, and hits Mattingly in the thigh.
I feel like I aimed down because I don't need to kill anybody. So I just let off one shot.
Mattingly immediately returns fire.
I got 4 rounds off, and it was like boom, 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 boom.
Then all of a sudden there's a whole lot of shots.
Mattingly fires 2 more rounds when he falls and takes cover. Almost at the same time, Cosgrove moves in and fires, stepping on Mattingly in the process. He has now also put himself in the fatal funnel, and although he's shooting, he appears to have no idea what's happening.
I see blinding, vivid, white light and blackness at the same time. I don't hear any gunfire at all, ever. And I did not have any pain sensation or any recollection that I'm firing.
He continues shooting blindly until he runs out of ammunition, a total of 16 rounds.
If you told me I didn't fire a gun, I'd be like, okay, I believe you.
In response to Walker's shot, Mattingly and Cosgrove together fire 4 shots into a chair, cupboards, and a stove in the kitchen. 2 bullets go into the ceiling and pass through the living room in the apartment above, where the man, his 2-year-old daughter, and babysitter waited. 3 more shots go into the living room wall to the right. And the officers fire 13 rounds down the hallway where Taylor and Walker stood. Taylor is shot 6 times on both sides of her body, in the abdomen and chest, her arm and leg, and twice in her foot. In all, these 2 officers fired 22 rounds in less than a minute. An FBI ballistics report found that both of them shot Taylor, and that one of the 16 rounds Cosgrove fired was the lethal bullet.
We both dropped to the ground, but I just hear her screaming, and
thinking they're under attack, some of the officers flee when they hear a pause in shooting.
There was a little bitty moment of no shots. I was like, here's the time to go, and then it all started up again.
We don't know the precise sequence of events, but Detective Hankison runs to the front.
I can hear the firing as I'm making the corner. I can see the flashes, the muzzle flashes.
But the only ones shooting are police. Even though all the curtains are drawn, Hankison blindly fires 5 bullets through the patio windows.
My only option was to return fire, and I did that to the muzzle flashes.
He moves and fires 5 more rounds through the bedroom window of Taylor's sister, who isn't home. 2 bullets fly over Walker and Taylor, but none hits them. The bullets that go into the living area pass over Taylor's sofa and kitchen table and smash her clock. 3 penetrate the wall and enter her neighbour's apartment. Those bullets also smash the kitchen table, hit a wall, and shatter the patio doors at the rear. A pregnant woman, her son, and partner were home. Hankison has been charged with wantonly endangering their lives. In total, the police fire 32 bullets, penetrating almost every room in Taylor's apartment. They hit saucepans, cereal boxes, and smash into her shower. They puncture shoes, shatter cleaning equipment, and land in her sister's clothing. And 3 minutes after police came to search her home, A fatally wounded Taylor is lying on the ground.
I'm just panicking and I'm telling somebody, I'm yelling help because she's right here bleeding and nobody's coming, and I'm just confused and scared, and I feel the same right now. That's it.
Months later, when Attorney General Daniel Cameron presented the charges against Hankison and said that Mattingly and Cosgrove's actions were justified, he emphasised that police did properly announce themselves.
Evidence shows that officers both knocked and announced their presence at the apartment.
But actually, the evidence is far from clear. In 911 calls immediately after the shooting, Taylor's neighbours don't know police are carrying out a raid.
Please get a police out here. They shoot bad. Something's going on next door, and there's bullet holes all the way through the wall, through our glass. I have a 5-year-old in here, so something needs to be explained to me.
And in statements police took afterwards, none of Taylor's neighbours heard the officers announce. This apartment's patio door was open.
I mean, I was completely unaware that it was cops.
2 teenagers in this apartment heard a commotion, but didn't hear police announce through their open window, their mom said.
They told me that nothing was said, that they just beat on the door. I said, so y'all don't know if it was them? She was like, they didn't say nothing, they just beat on the door.
And the family who lived directly above Taylor also heard nothing.
Before the gunshots come out, did you hear anything?
Conversations or anything like that, people talking? No.
In their statements and in interviews with the Times, over a dozen neighbours say they did not hear the police. Attorney General Cameron's assertion rests on the accounts of police officers and a single witness, Aaron Sarpy, the man collecting his daughter that night and who saw the police when he came outside. In his first interview with investigators, Sarpy was asked what he heard when he went back inside.
Did you ever hear anyone identify themselves as police?
No, nobody identified themselves.
Months later, he told police his memory was foggy, but that he thought officers did announce. And beyond what the police said, this critical grand jury conclusion rested on his entirely inconsistent account. After the raid, the scene outside is chaos. Officers tend to Mattingly, but an ambulance that had been staging nearby is nowhere to be found.
Fuck is EMS? They were 15 minutes away. Somebody give me the radio with SWAT on it.
They radio the SWAT officers across town,
EMS on Springfield.
who are surprised by the call.
We're Springfield. They're requesting armor down there. We're going to go ahead and take it. Let's go.
They head for Taylor's address.
It's an apartment.
I didn't know they were in that tonight. I knew it was part of the investigation.
As SWAT arrives, close to 40 police vehicles are already at the scene. Around this time, Taylor's boyfriend, Kenneth Walker, is being arrested.
You've been hit by a bullet. That's unfortunate. Keep walking backwards.
Hey, come on, we need to get moved because there might be a victim inside.
Walk backwards. Keep walking backwards. You're scared, right?
Walk back, I don't send this stuff. Walk back to me.
Walker had called 911 and neighbours had heard his pleas for help.
You're going to fucking prison, that's what's going on.
But at 1 a.m., almost 20 minutes after the shooting, the police still don't know Taylor is critically injured inside.
There's somebody in there dead?
Yeah, my girlfriend. It's her house.
We have to go in if there's somebody.
Yeah. What is this about? My girlfriend is dead.
I don't get. Keep walking.
As Walker is being led out, SWAT gets ready to secure the apartment.
Hey, there's a kid upstairs. He's not. It's a kid upstairs, little kid. What the? Hey, front door. Moving. Short. Clear. Left side clear. Go ahead and get EMS in here. Let me check her pulse.
Only now, half an hour after the raid began, does an EMT finally check Taylor.
Yeah, there's a hole right there.
And later, as 2 officers stand guard, they take in the scene. They see Taylor's uniform. She worked as an emergency room technician in city hospitals. They note the bullet holes.
Body level. Hey, can anybody advise if we talk to the neighbors directly above this apartment? There's gunshot holes in the ceiling.
Outside, the SWAT officers debrief on what they've seen.
Hey, camera's off there, bike.
Yeah, mine's off. This is the fucking one that said that it is to do.
The SWAT commander who was called to Taylor's home after the raid was later interviewed by investigators.
We just got the feeling that night that something really bad happened.
Dale Massey, a 20-year police veteran, was highly critical of what unfolded. He said there was no coordination with SWAT.
We had no idea they were going to be at that apartment that night. I would have advised them 100% not to do it.
And that executing another warrant at the same time may have compromised Taylor's safety.
We treat safety very important, right? So like simultaneous warrants, bad business.
Narcotics officers testified that they didn't know Taylor had a new boyfriend, that her sister lived there, or that her 2-year-old goddaughter regularly stayed. Massey said the department had a history of poor intelligence gathering.
Back in the day, we would take a lot of detective information and take it as golden. Not anymore, because so often there's no kids, there's no dogs, we're told, there's kids and dogs. So we have an exhaustive recon process that we go through.
He said standing in the doorway, the fatal funnel, as Mattingly and Cosgrove had, was a tactical mistake.
Is it practical, or is it even common for 3 people to be in what we consider the fatal funnel?
Absolutely not, no. You would never put, yourself in that situation.
And that there's a right way and a wrong way to conduct a raid. You knock, announce, and give people ample time to leave.
We're not going to rush in to get dope. We're not going to treat human life more important than any amount of dope, right?
And just to be clear, no drugs were ever found at Taylor's. His harshest criticism was of Hankison's blind shots into the apartment.
You have to know, A, what you're shooting at, B, what's in front of it, and B, what's behind it. There's no other way you can operate. It was just an egregious act.
Under Kentucky law, Kenneth Walker had a right to stand his ground against what he believed was an aggressor, and the police in turn have a right to self-defense. But in this analysis, the killing of Breonna Taylor resulted from poor planning compounded by reckless execution. Louisville has instituted police reforms, and Taylor's family received a substantial settlement, but the case isn't closed. Investigations and lawsuits are ongoing, and 9 months after Taylor was killed, her family is seeking a fresh inquiry into the officers involved.
Pages, I believe approximately 2 pages of the transcript that are relevant to the actual shooting, and another group of pages, approximately 10 pages, I believe, that are relevant to the issue of the neighbor upstairs or the visitor upstairs appearing on the landing. So that's what we would ask be those portions of the deposition that are relevant be used, not all 228 pages, which are most of which are not relevant.
All right, Mr. Matthews.
Well, Judge, with reference to the Mattingly deposition, I concur with what Ms. Whaley just stated. That deposition was kind of all over the place, and it devolved into some personal attacks back and forth between the witness and the questioning attorney. And I agree that it was it would be very difficult to redact that, and I think that's why we decided not to use it. On the other hand, with reference to Detective Cosgrove's deposition, and I don't believe the whole 228 pages is testimony. There's a lot of stuff at the end, but that is just citations to page numbers and so on. But the entire deposition is related to the events that occurred on March 13, 2020 at 3003 Springfield Drive, and I believe that it's all relevant. And I don't believe there's a whole lot of material in there that is not probative or relevant. And with reference to the specific sections that Ms. Whaley just cited, the second portion of the transcript that she would like to use is a section where language is used referring to Brett Hankison as angry and yelling, and basically the attorney doing the questioning testifying. There was no opportunity for Brett Hankison to cross-examine on that issue, for that matter, and for that reason, I think if you take it out of context or just cherry pick it out of the deposition, it's very prejudicial to Mr. Hankison. But if it's read in conjunction with the entire deposition, it's a little less stinging. So that's why I feel like it's an all or nothing proposition there.
Who was there representing Mr. Hankison at Mr. Cosgrove's deposition?
Kyle Vaughn and Ibrahim Farik.
Okay. All right. Is there a way that you all can get me that deposition today?
Yes, Your Honor. We actually, I could email the transcript, and the video I believe, was delivered to the court Friday. Our investigator was going to come and pick it up, and it's probably still there. The video, it's a flash drive with the video, but we can email the transcript.
Okay.
And it is 200 pages of testimony. I just looked at it. 200 of the 228 is actual testimony.
All right. So what I would ask you both to do then is to take another look at that transcript, and each of you give me the pages that you believe are relevant to our trial. And then I can make a ruling based on that.
Can I ask, Barbara, do you have any idea how long the video is?
I do not. I haven't seen it. Mr. Farag might know since he was present for it. I don't know.
Mr. Beck, were you present?
No, Your Honor, I was not. Mr. Cosgrove was represented by Bill Bramall and Scott Miller, who represented him with regard to his employment situation with LMPD, but I was not present.
Does Mr. Cosgrove have just a guess as to about how long this video deposition lasted?
Judge, this is Miles Cosgrove. If I had to guess, it would be 2 hours to 2.5 hours.
Okay, thank you. All right. Well, based on Ms. Whaley's statements, Mr. Matthews' statements, taking in conjunction what Mr. Beck has told us that he has learned from the Department of Justice, I will find that Mr. Cosgrove does have a legitimate Fifth Amendment privilege that then makes him an unavailable witness for the purposes of our trial, and then we will sort through this civil deposition as to which parts of, if any, are to be admissible before the jury in this trial. All right. Anything else on that issue, Ms. Whaley?
No, Your Honor.
Or Mr. Matthews?
No, Your Honor.
Or anything, Mr. Beck, that you wanted to add?
No, thank you, Your Honor.
All right. So I'll excuse Mr. Beck and Mr. Cosgrove. Thank you all for calling in. Ms. Whaley and Mr. Matthews, if you'll remain on the line just for another few moments so we can maybe preliminarily talk about jury instructions.
Thank you, Your Honor.
Thank you. All right, Ms. Whaley, I think I had mentioned on Friday that I was hopeful that we could just at least preliminarily talk about the instructions. Obviously, it's 3 counts of wanton endangerment in the first degree. Anything else that you were going to propose, Ms. Whaley?
No, Judge. That's what we have drafted some proposed instructions.
Okay. And Mr. Matthews?
Yes.
Judge, I am working on the assumption that you have some standard boilerplate instructions that you give in a criminal case.
Yes.
In addition, I have prepared 6 proposed instructions that I will finalize this afternoon, but they all relate to justification and the United States Supreme Court decision of Graham versus Connor.
Can you give me that site?
Yes, if you give me just a second here.
Sure.
Graham versus Connor is 490 U.S. 386. It's a 1989 case. I can give you the Supreme Court or lawyers or LED at sites too, if you would like.
Oh no, that's fine. That's fine.
Okay.
Thank you for that. All right. So if I could ask,
Your Honor,
go ahead.
We have a case as well. I can actually email that along with our draft instructions,
Okay.
which is Commonwealth versus Caudle. And that site is 540 Southwest 3rd, 364, which is the Kentucky Supreme Court, 2018.
Okay. All right. Thank you. And then if both of you would email your proposed instructions to my staff attorney, and it's Bob McClure, MCCLURE at kycourts.net.
So there's no dot, it's just Bob McClure.
No.
Yes, we will do that.
I will do that also.
Okay, thank you. And so I'll be looking for that, the transcript. I'll take a look at these cases that you've cited, and then when you can get the instructions emailed as well, I'll take a look at those. All right. Anything
Thank
else?
you, Judge.
Anything else we should talk about today?
I don't think so.
Okay. Anything, Ms. Whaley?
Judge, there is one other issue in regard to the witness, John Mattingly. We would ask for a missing witness instruction, which has been approved by both the U.S. Supreme Court and the Kentucky Supreme Court regarding a witness who has claimed the Fifth Amendment, and obviously a jury cannot be told that, but under these cases, which I can also email, Clayton versus Commonwealth, which is a 1990 Kentucky Supreme Court, 786 Southwest 2nd, 866, and then Bowles versus United States, that's BOWLES, and that's let's see, the U.S. site. I don't have the Bowles site.
If you could just email it to me when you get the chance.
Yes. And under those cases, the jury can be advised simply that in the case of John Mattingly, potential witness, let's see. The court, I'm just going to quote from the Bowles versus United States. The court can instruct the jury that they should draw no inference from, and this witness was Smith's absence, because he was not available to either side. And that's it. That the jury should draw no inference from his absence because he was not available to either side. So we would ask that instruction be given regarding Mattingly. If for some reason we end up not using Cosgrove's deposition, then we would ask that also be given in regard to him.
Do you think if I gave such an instruction as to Mr. Mattingly that the jury may conclude that as a result of his injuries he was not available? I don't know that there's been any testimony. The testimony that I've heard so far in the trial was that he was shot, that it was serious, that he was taken to the hospital. Certain people saw him at the hospital, that he was expected to live, and I think that's where it's been left. I don't think, there's been much testimony about his recovery since that time.
Well, we could put a witness on to establish that he recovered and has retired.
Okay.
I guess, can I interject here for a minute?
I didn't know if you'd had a chance to give this any thought at all, if this is new information to you regarding this missing witness instruction.
Well, I mean, my feeling is that he has never formally been called as a witness and failed to appear, so why would we call attention to it?
Well, because we can't call him when he's going to assert the fifth. He can't be called in front of the jury.
Right.
Well,
but if you want
I guess I would have to think about it more, but
sure.
I'm not sure it makes much difference.
All right. If you want to, spend some time this afternoon looking at that as well, and anything that you might want to respond, if you'll just email that to me or to my staff attorney also.
I will do that.
Okay. All right. Then I will look forward to seeing you all tomorrow morning at 9:30.
Thank you, Judge.
Thank you.
Thanks. See you then. Bye-bye.
Bye.
See ya. Bye.
Sufficiency of the affidavits, the amended affidavits.
His supplement, I think, addressed the issues that we raised in our response.
All right, go ahead.
And Judge, I'm not sure that the affidavits really have much meaning in a petition for change of venue, especially in this kind of case here. So, but whatever, I think we've overcome that issue. The balance of this case involves the defendant Brett Hankison's constitutionally guaranteed right to a fair trial with an impartial jury, and the venue of or location of the trial plays a major role in whether he can get a fair trial, which is why we think that the court ought to seriously consider granting the motion. There's been an extensive amount of adverse publicity since this incident occurred on March the 13th of 2020. And all of it has been directed at basically the LMPD and more specifically at the officers who were involved in the attempted execution of the search warrant on Springfield Drive, and more specifically at Brett Hankison, since he's the only one that was charged with anything criminal out of this whole incident. I don't mean to suggest that all of the potential jury persons in Jefferson County cannot be fair and impartial, far from that, but I think there are a large percentage of people who could not be fair and impartial, and I think every resident of Jefferson County is aware or will be aware of what has occurred since March 13th of 2020, and I think that there's subliminal pressure, if not direct pressure, on all of those people, and fear of what could happen should they sit on this jury and should they render a verdict that is not the verdict that a large segment of the population wants. They saw what happened last summer here in Louisville, and I think that has to weigh, just by the very nature of human nature, it has to weigh on the minds and hearts of the people that were asked to sit on this jury. They have to return to their homes, their places of employment, their places of worship, where they shop, where they play. And when people know they're on that jury, I think they have a natural inclination that they will be afraid of what people are going to say or do with them. The publicity that has occurred has been extensive, and I think the court can take judicial notice of the publicity that has occurred with reference to the incident itself, but also there has been an extensive amount of publicity in the media about Brett Hankison himself related to unsubstantiated allegations of sexual assaults and unsubstantiated allegations of planting drugs on people. I even saw one article that was critical of him because of the amount of overtime he works. So I think that the air has been poisoned so much around Jefferson County, and not just Jefferson County, not just the city of Louisville or Jefferson County, but across the Commonwealth, across the country, and around the world. But it is not as pervasive in those other locations as it is right here in Jefferson County. And I think that all that negative publicity creates a presumption of prejudice against him. But I think also there's plenty of evidence of actual prejudice against Brett Hankison, and that takes the form of many of the exhibits I attached to the motion. When I came in here today, there are still banners of Breonna Taylor hanging right outside of the courthouse here. But more than that, Judge, there have been wanted posters posted around town. There are 26 billboards. I don't know if they're still out there, but 26 billboards that were paid for by Oprah Winfrey, all referring to Brett Hankison and John Mattingly and Miles Cosgrove as murderers. There have been stickers stuck on telephone poles around town. There have been postcards that have been mailed to people here in Jefferson County, all of which refer to Brett Hankison as a murderer. Social media has been going nonstop since his name came out. I just think we've had comments by the mayor, by politicians, by the former police chief, by athletes, by so-called celebrities, all directed at the LMPD, at the officers involved in the search at 3003 Springfield Drive, and more specifically directed at Brett Hankison, referring to him as a murderer. And that constant barrage of publicity and all those other things I just mentioned have got to create a prejudice amongst the potential jury pool. And for that reason, Judge, I think that the change of venue is warranted. In the cases I've researched, most of them are homicide cases. This case is not a homicide case. It's not related in any way. The charge is not related to Breonna Taylor in any way, and yet the media has treated it, as is evidenced by the media here today and as evidenced by the media out in the hallway, as basically as a referendum on the homicide of Breonna Taylor. It's not a simple wanton endangerment case. We need to, and I don't think there's any way we can divorce that, and divorce, more importantly, the jurors' minds from the fact that this case relates to Breonna Taylor. So it concerns me that the case law that I have reviewed, for the most part, deals with homicide cases and cases that with brutal facts and so on, but this isn't that much different. And in those cases, just about every one of them that deals with a change of venue petition is appealed because that petition was denied. And just about every case, except for one that I found, upholds the ruling of the trial court that the venue change was properly denied. I think this case here is a totally different animal. I think times have changed since most of those cases were decided, in the sense that there's a whole lot more publicity and publicity news outlets out there now. I don't know of any of those cases that involved the posting of billboards and stickers and wanted posters and so on. But the bottom line is, Judge, that if ever there was a case where a change of venue was warranted, I think this is it. And I recognize those cases there are no firm guidelines. There's no statutory guidance in whether a motion should be granted. It's all discretionary. It's with you using your discretion and common sense. And all I would argue to you is that if there was ever a case that merited a change of venue in order to protect the rights to a fair trial of this defendant, this is the case. One of the Attorney General's arguments is that there is cost and inconvenience associated with changing the venue. None of that trumps Brett Hankison's right to a fair trial by an impartial jury. And for that reason, I would ask you to grant the motion that we filed. Thank you.
All right, thank you. Mr. Lisowski?
Judge, like Mr. Matthews pointed out, we filed a brief that I think sets out our position in the relevant case law, but I'd like to make a couple of points that I think are important and disagree with Mr. Matthews respectfully on a couple other points. Venue is important. It's built in the county in which these crimes occurred. That's in our Constitution and the statutes authorized and put in play by our legislature. They do that because it's important in the communities where these crimes occur to have a fair and impartial jury from that county decide the facts and render their decision on guilt or innocence. And it's equally important here, unless there's compelling reasons to change the venue. There has been pretrial publicity. There's no question about it. But the pretrial publicity has been difficult and pointed at a number of individuals and entities other than Brett Hankison. It's been pointed at Attorney General Cameron, It's been pointed at the mayor, at the police department in general. There's not been pervasive and focused adverse publicity pointed at Mr. Hankison. The pretrial publicity alone is not dispositive of a question of whether change of venue is necessary. Pretrial publicity is just the beginning point. What has to be determined is that pretrial publicity such that a reasonable conclusion could be drawn that no fair jury can be selected for Mr. Hankison's case? We believe it can. The only case that has been overturned, that's the Jacobs case in Knox County, is far different from this one. That had a population of 15,000 in Knox County. We have 765,000 or more people in Jefferson County. It's a diverse population made up of many different races, religions, work, and many other different statuses of people in this particular community. And why is that important? Because that provides us a resource that can be used through rigorous individual voir dire, as the court has already said that it would do if we stay here, as occurred in the Hubers case, through rigorous and effective individual voir dire from persons who are brought from these diverse parts of our county. I believe that we can effectively identify the number of jurors necessary who are unbiased and willing to consider a decision based only on the evidence they're going to hear. That's what our courts here in Kentucky favor, as noted in our brief. The courts here, as Mr. Matthews points out, gives great discretion to you, Judge, to decide what's appropriate. And they also favor, as they did in Hubers and Whitler, the use of individual voir dire, and if the court deems it appropriate, questionnaires to ferret out individuals who may be biased one way or the other. And also, more importantly, to identify people who are not biased. They may have heard about Breonna Taylor. Probably few people have not heard about her death. But there are many people, I believe, in this community, in the community of Jefferson County where these alleged offenses occurred, who haven't formed an opinion. and who would be willing to hear the evidence and decide fairly whether we have proven our case beyond a reasonable doubt without being interfered by Oprah Winfrey's bulletin boards or any other miscellaneous and unimportant data. I believe we have that kind of community here. It may take more than the usual couple hours that occurs in most voir dire that we've had in your courtroom in the years you've been a judge here. It may take several days. In Minnesota, it took 2 weeks. In a case far more graphically prejudicial it faced to the population in Minnesota, but they found a way to find 14 jurors who weren't biased through good and effective examination of those people individually. They may have also used, I believe, questionnaires. Our courts favor that, and I believe they favor, particularly in a county as large as ours, that's the appropriate way to decide it. If we come to a point where the court and the parties, it's obvious that and reasonable inference can be drawn that we're just not going to be able to get the requisite number of unbiased jurors, then that's the time, I believe. At that point, we've done what we can to give this community an opportunity to have unbiased jurors selected. Then we can look to alternative counties as set out in the relevant statutes 452. But I think the first and foremost, this case, we need to give the opportunity for people in this community to hear this evidence and to make an unbiased decision about whether we met our burden on these 3 counts. And as I pointed out, clearly there's been a lot of publicity, and undoubtedly virtually anybody we bring them will hear it, but that publicity has not pointed at former Detective Brett Hankison. It's pointed, as I point, to a number of individuals, including my boss, General Cameron. So, and I believe, and I strongly urge the court to allow us the opportunity with proper planning, with identification of potential juror pools, that we take the opportunity to individually voir dire these people and talk with them. The court will be able to ask questions. Mr. Matthews will be able to ask questions. Myself or my colleagues with the Special Prosecution Team will be able to ask questions. From those, I'm convinced we can determine who is biased, and that bias will prevent them, whatever side they're on, from being a juror. But I firmly believe that with that process, that we can select the 34 jurors we usually put into the panel, and then with the preemptive, with the strikes that were allowed, I think we could come to the 14, 15 jurors to hear this case, and 12 unbiased jurors to decide it. So now I believe that's consistent with Whitler and other cases in Kentucky that favor that approach. A good example, the court's got our cases, but a good example was a 2020 case, Commonwealth versus Huber. It's unpublished, it's before you, but that was a case in which the defendant had been convicted in Campbell County, a county of 115,000, if my memory is correct, 1/6 the size of Jefferson County, but they noted the size of the county was important because it was diverse and represented a population from which the trial judge felt confident they could find the jurors necessary and unbiased to hear that case. Importantly, that the defendant in that case had been convicted, and that conviction was overturned on appeal. The reasons I don't recall, and it's not important for our discussion this afternoon. But many of the jurors knew that defendant had been previously convicted, which, as the court knows, having been an attorney for many, many years, and there's a retrial for whatever reason, the first rule is nobody mentions the previous trial because of the potential prejudice. That came up. Nonetheless, the court found that they were able to work with those jurors even with that knowledge and have upheld that conviction, finding that the court did properly do the voir dire, and through questionnaire and voir dire found the requisite number of jurors that were unbiased and willing to hear the case and make a fair decision based on the evidence. I think we can do the same. I think we can follow Huber's and apply those same principles that the trial judge did there and find the requisite number of unbiased jurors, do it here in Jefferson County where this alleged crime occurred in this community. And we can find people who can give this man the fair trial he's entitled to. And I'm convinced we can do that. And I believe the appropriate way to do it is to let us go forward with proper planning and whatever the court feels and the parties agree to, our on questionnaires, our selection, and how many jurors we need to get. I realize there's some complications there, but I believe those complications far outweigh the importance of having this trial consistent with the constitutional and statutory provisions in the county in which these allegations occurred. Thank you, Judge. I stand by the briefs that we filed in response. Thank you.
Anything in response, Mr. Matthews?
Judge, just briefly, with reference to the pervasive publicity that has not been directed directly at Brett Hankison, I would disagree with that in the sense that the most pervasive negative and prejudicial publicity has been directed at the LMPD, and more specifically at the 7 officers who were involved in the attempted execution of this search warrant. And as a result of that, only 1 officer is in this courtroom facing criminal charges, and there's a large segment of the population that wants revenge for the death of Breonna Taylor. And unfortunately, Brett Hankison is the only person at this point that can be the target of that revenge. And for that reason, I think that alone suggests that the pervasive publicity has been extremely harmful to him and damaging to his right to get a fair trial. The comparison to the Minneapolis case, again, I think you're trying to compare apples to oranges in that case. This case is entirely different. I saw some of the beginning of that jury selection process, just a shot of the outside of the courthouse, and it's like an armed fortress up there. And again, coming in here today, there are still Breonna Taylor things. That kind of stuff can't help but affect the jurors they're people we're going to ask to sit as jurors in this case. They know that there's a lot of pressure. And for that reason, again, this is an entirely unique case, but I think if there's ever been a case that merits a change of venue, this is it. And I'd ask the court to grant the motion. Thank you.
Okay, thank you. Obviously, there has been an overwhelming amount of publicity in this case, and it's not just been limited to publicity here in Jefferson County. The publicity has been very far-reaching. It's been on the national news. The stories have been on the national news, many, many times. There's probably been more publicity in Jefferson County because the events occurred in Jefferson County. But that's not to say that our surrounding counties have not also experienced that very same publicity. And I was really hoping today to hear something about how far-reaching the local media is to the surrounding counties, and whether going to an adjacent county would even help with the issue. I think I may have mentioned to you all in a previous hearing that as a defense attorney, I made a motion for a change of venue and it was granted, and we moved the case to Boyle County, to Danville, where we tried the case. And I will tell you what happened was that the publicity followed the case. When we arrived in Boyle County to get started on the case, which the trial took close to 3 weeks, the newspaper there in Danville had a front page, full page story the days preceding the trial, detailing the facts of the case, detailing what plea bargains that co-defendants had received, what their expected testimony was against my client at the time. We ended up having to do individual voir dire in Boyle County because of the publicity that those potential jurors were exposed to. So I don't think that we can just move this case to another county and not have all of that publicity follow us there, not have all of the security concerns follow us to that other courthouse. I'm not at all dismissing your argument, though, about a change of venue, and I do take that very seriously, Mr. Matthews, because of the pervasive nature of the pretrial publicity that has occurred. I do, however, think that we should give it an opportunity to try the case here. I read a case recently, I think it's an unpublished decision from the Supreme Court of Kentucky that talks about pretrial publicity, about individual voir dire with jurors, where defense counsel had made a motion for a change of venue, and the court upheld the trial court's decision to not change venue in that case, but made it clear that one of the things that was taken into account was that the trial judge excused immediately any juror who said, "I have formed an opinion about the defendant's guilt," and did not allow any type of rehabilitation. I would follow that same model. If a potential juror said, I've already formed an opinion about Mr. Hankison's involvement in this and whether he's guilty of these wanton endangerment charges or anything else in connection with this case, I would excuse that juror and we would move on to the next juror. It may be that we're not going to be able to seat a jury in this case. I don't think any of us know that at this point. I noticed one of you mentioned the Jacobs case, and in reading the Jacobs case, the attorneys there had done some polling, some telephone polling of the community, and obviously that was a much, much smaller community than what we have here. But they called 100 people to find out had they, reached decisions about Mr. Jacobs' guilt or innocence, and by far the vast majority of them had. And not only that, most of the jurors knew that he'd previously been convicted of a homicide case. So the judge there had allowed people to sit on the jury who had said, I believe him to be guilty, but I will go and try to go into this with an open mind. And the Supreme Court said that's not good enough. And I certainly wouldn't do that in this case. Mr. Hankison clearly is entitled to a fair trial, and we will do our very best to find jurors who I'm sure will have heard some publicity, but have not formed the opinion as to whether he is guilty. I think it also has to be pointed out that in all of these other cases that have been referenced today, it was not a police officer or a former police officer who was on trial, and there are very many people in this community who hold police officers in very high regard. So I think that's a distinction as well, that we may be able to get jurors who will be open-minded and listen to the evidence and decide the case solely on what they hear in the courtroom and not based on media reports or preconceived notions about what took place that evening. So at this point in time, and it's the kind of thing that I'm going to keep an open mind about because there will probably be more publicity as we get closer to our trial date, and that may cause me to change my mind. But at this point in time, I do think that the prudent thing to do is to try to get a jury seated here in Jefferson County. And if we discover that we cannot, then we will move the case to another county. And I think that's going to be a hard discussion about where to move it to. And I wouldn't mind if you all would, maybe go ahead and have that discussion between yourselves and see if you can come to an agreement about, because I just don't think going to Bullitt County or to Shelby County or to Oldham County is going to cure the issue, because I think their media reports primarily are coming out of Jefferson County. All right. In terms of your second motion.
Your Honor, may I ask one question with reference to this jury selection process? Would the court consider using a questionnaire?
Yes.
Pre bringing the panel in?
Yes, I would.
Good. Thank you.
I've not done that before, but I would certainly.
I've done some, and I'll work with you on it.
I would certainly do that.
Because I think that may speed the process up, if nothing else. Secondly, Judge, with reference to the motion to view the scene, that is something that the Kentucky law permits. I think in a situation like this, it greatly enhances the jury's ability to understand what the nature of the charge, what the charge is all about. In this case, Officer Hankison is charged with firing his weapon through Breonna Taylor's apartment into the adjacent apartment. And I think just for the jury to get a feel for the layout of where he was, where the adjacent apartment is, and all that would be very helpful to their understanding of the facts. And for that reason, I would ask the court to allow us to take the jury out to see the scene.
We don't disagree.
Well, when you say the scene, I don't know whether there are people currently living in the apartment or not. Are you talking about going into the actual apartment?
Just mainly the outside of it. If the apartment was vacant, it'd be great to go inside. I don't know what the current status is, but I think just seeing the layout of the buildings and the scene itself would be helpful.
Mr. Lisowski?
We don't disagree. We talked about it with my colleagues, and we agree. The same issues, as there are occupants in there, and with proper planning, it might. There's also that hallway that the jury may want to see, but I think it's going to be one of these things. We don't disagree, and we're fine with it. I've done several, and you've probably done them. It takes a little bit of logistics. The parties have to cooperate. You also, we have to talk about just when I did it, there wasn't any discussion with the jury. In other words, somebody didn't walk around saying this is where Mr. Hankison was and this is where he wasn't. Or it's usually at a time when they've seen evidence, and then, all right, we're all on the same page then. So as with the questionnaire, we can talk about it. We had the same questions. Are people living in there? And certainly that presents a significant problem if there's personal residence of somebody. But as we get closer, we can talk about that. And can I go back to the questionnaire? If we're there, and we're going to need to have some logistical working together, because we've got a number of them. I assume that I haven't tried a case here for a couple of years, but you still have every 2 weeks you got 300 or 400 come in. And so I guess we'd have to identify.
Well, we do, except that now with the pandemic, things are a little bit different, and I don't know how things will be towards the end of August. But you're right; that's how we would normally.
So do we? We'd have to identify this, to give them sufficient time where we get out and we get these questionnaires, how we do it, all of that, and so it may be some point. In the next month or two, we can get back together. We can talk about the questionnaire. Invariably, there's probably a lot of things that Mr. Matthews, and the prosecutors can agree, and there may be other questions we may not. And the questionnaire needs to be got out in such a way that the information comes back in a timely manner. We've identified 200 that we may use as potential. So maybe getting together in April or so, or May.
I think so too. I'm thinking maybe just a month from now to get back together again, because I think there are some logistics involved. I'll have to get with the jury pool to see how much notice they need to be able to send out the summonses.
Have you done one, Judge, with a questionnaire, even when you were a practitioner?
No.
All right, okay.
I think I asked. I think I was denied.
All right. Well, I've done it federally. It was easy to do because they're on there for 18 months. And here they're just 2 weeks. So there has to be, it's something we need to talk about. Maybe I'll interact with Mr. Matthews and put something together with my colleagues, and we can start talking, and then maybe get together where we can talk about some of the logistics and any objections or agreements we may have on the questions.
That's fine. In terms of going to the scene, I still have some concerns about that. And I don't know what you all have planned in terms of if there's already video of the scene. I'm sure there's photographs of the scene, but there very well may be a crime scene video that was taken as well. And how well that will depict any concerns that both of you may have regarding the jury's understanding of the layout. I have had a couple of cases where we've gone to the scene, but not with the kind of publicity that was attached to this case and the security concerns that may be there. It's not the kind of thing that, we can make it go do it at a last minute. So I think that's something we'll have to talk about a little bit more as well. And I can get with our sheriff's department and talk with them about any concerns that I haven't even thought of. So before I sustain that motion, I want to give that one a little bit more thought.
And Judge, I have had some experience with that and can probably throw out some ideas when we get to that point.
That's good.
And the same with can we talk a little bit more about the jury pool? As far as the questionnaire, I don't know what the procedure here is, but a lot of times, usually in homicide cases, they pick a special veneer.
We do that. We do that in capital cases, yes. But I don't know that it has to be limited to that. It's just that's typically how it's done. I would think with the number of jurors, prospective jurors that we're going to need, that the jury pool may very well say we're going to have a separate panel just for this trial.
I think just from a questionnaire standpoint, that's more practical.
And I have no idea how many to begin with, how many jurors to start with.
I don't either. I mean, it's something we just have to think about.
A case I was involved in, we started with, I think, 1,000. Many of them didn't even respond to the summonses, and many had legitimate excuses that eliminated them from the beginning. And it ended up we probably had 250 people to choose from.
Okay. So. And then you were able to get a jury from that?
But far short of the 250, actually.
Okay.
How many do we usually summons? 400 and maybe 250 show up?
Well, we summons way more than that in the hopes of getting, I think, I forgot how many actually they do hope to get, 300, 400, somewhere in there. But a number of more summonses go out for not having accurate addresses or the person's deceased or that sort of thing. People who don't respond.
Okay.
All right. Anything else that we need to take up today other than getting another court date?
Nothing, Your Honor.
Nothing. Thank you, Judge.
All right. Let's see. How about Friday, April 23rd at 11 o'clock?
Judge, what time was that, 1 o'clock?
11.
11. Okay. I believe that's fine.
That would work with me, Judge.
And that would give you all enough time to get together to talk about proposed questionnaire and just get that started?
Yes.
Okay. All right, let's give that a try then. April 23rd at 11. Are you okay with doing that in person, or would you rather do it telephonically?
My preference is in person, Judge.
Okay. You fine with that, Mr. Lisowski?
Yes. Oh, yeah, that's fine.
All right. All right. Thank you all.
Thank you.
Thank you. Whatever you think would be appropriate to call you.
608 680.
At your office?
That's my cell. Oh, yeah, I'll give you a card here.
Attorney General's office for some reason, and there was something in that case that said, I think there was maybe on appeal, something was raised about the legitimacy of the Attorney General's office prosecuting a case instead of the Commonwealth actually prosecuting it. And the Supreme Court had said it's the better practice for the Attorney General's office to make a record of its authority to prosecute an indictment. I didn't think that that had been done yet in this case, and that you might want to do so.
Yes, Your Honor. Of course, this case came to the Attorney General's office through the, under Chapter 15, the Commonwealth attorney recused in writing, and the Attorney General, under the authority of Chapter 15, has the authority then to prosecute the case, either as keep the case in-house, which was done in this matter, or to call on another Commonwealth attorney to assume jurisdiction. So I believe that the letter sent to Commonwealth Attorney Wine is in the record. If not, we'll make sure as soon as possible to have that filed in the record. And the letter from the Attorney General, the letter from the AG's office assuming jurisdiction. We'll make sure that's filed in the record.
I don't know that I see it here currently, but I will look further and see. I have your notice of entry of appearance, but it doesn't really give the basis for why you're entering the appearance. So,
yes.
You're right. There may be other things that you have filed, and I'll take a closer look at the file. Mr. Matthews, did you have any questions about that at all?
No, I do not, Judge.
All right. Thank you. All right. So, Ms. Whaley, was that all you felt like you needed to put on the record in terms of bringing the court up to date?
Yes, Your Honor.
All right. Thank you. All right. Mr. Matthews?
Your Honor, I've been furnished with, as Ms. Whaley characterized it, a voluminous amount of discovery. I've made it through that discovery, and we're ready to go, basically.
All right. And when you say ready to go, are you saying you're ready to set a trial date?
I think so. There's the discovery has been provided. I don't have any questions about it, and I don't think there are any outstanding procedural issues at this point.
Okay. All right. Ms. Whaley, are you ready to for the court to set a trial?
Yes, Your Honor. Provided we could work around currently scheduled other proceedings that we may have scheduled. And I don't know what the court's calendar is, but we are ready. We can set a trial date.
All right.
Your Honor, if I may interject, I do intend to file at some point a petition to change the venue of the trial. And I don't know how the court would plan to proceed on handling that.
Well, I think we would have to schedule a hearing once you file that motion. Do you know when you'll be filing? Do you know when you'll be filing that, Mr. Matthews?
Well, I was kind of waiting to see what we did today as far as what we're talking about in terms of scheduling a trial.
Okay. Well, obviously with COVID, it makes it a little bit more difficult to know. I know that the Chief Justice has said in one of the more recent orders from the Supreme Court that we should be able to start trying cases in April. Now that date has been changed a couple of times with the Supreme Court's orders. I'm not terribly optimistic that this spring is going to be able to, that we'll be able to actually have trials. But you all can tell me when you think you would want me to start looking for a trial date. And Ms. Whaley, could you possibly, if you could, give me an idea of how long you think the prosecution's case would take to try?
Excluding jury selection.
That's fine.
I would anticipate 3 to 4 days for the Commonwealth's case.
Okay, thank you. All right, that gives me an idea. All right, well, let's see. Do you want me to start looking in the summer? Do you want me to start looking in the fall? Ms. Whaley, do you would
ask, yes, sir. I'm sorry, Your Honor, I didn't mean to interrupt.
No, you didn't. Go ahead.
We would ask that the court start looking the week of July 19th and from there out.
Okay.
Our prosecutors have other trials scheduled through May, June, and into the 1st of July.
Okay, that's fine. What about you, Mr. Matthews?
Judge, I will be gone that last week of July. Beyond that, I'm fine.
All right. All right, let's see what we have.
I do have a week-long trial set beginning August 9th, allegedly. But again, that's...
How about August 31st?
That works for me.
Ms. Zakaria, do you have any trials set at that time?
No, that works for me as well.
That'll be fine for me.
And it works for me.
All right. Well, that was easy. All right, August 31st, 10 o'clock to start the jury trial. And then, so Mr. Matthews, now having that date in place, when can I expect to see your motion regarding venue?
I would think that probably within the next 2 weeks.
In the next 2 weeks. All right.
Yes.
Ms. Whaley, do you want me to go ahead and schedule a hearing on that?
That would be fine.
Or do you want to wait to see the motion first before we get the hearing date?
I think we can go ahead and set a date.
All right. I think I would like to do that hearing in person, if you all feel comfortable doing that.
I would much prefer that, Judge.
Ms. Whaley?
Yes, we would. Yes, we would prefer in person.
All right. How about Thursday, March the 25th at 1:30?
Under the Supreme Court order, would that in person be permitted before April 1?
I think so. I mean, I think the jury trials are April 1. I think the court the trial courts on their own can make a determination of necessity for in-person. But if you want me to wait until April, I can do that if you feel more comfortable.
As long as the court, as long as we're in compliance with the Supreme Court's order, that's fine. That's fine. The 25th.
Yes, we'll obviously still maintain social distancing in the courtroom as we're conducting this and limit the number of people who can actually be in the courtroom. So, all right, Mr. Matthews, does that work for you?
Yes.
All right, March 25th at 1:30 for the hearing regarding change of venue. And Mr. Matthews, I don't know how much thought you've given to this, but do you have a county in mind that you are asking the court to change venue to?
Well,
and
Judge,
if you don't want to say that, that's fine.
Well, I don't have a specific county, but I believe that the statute says it should be an adjacent county, unless that is not feasible also, and then I assume any county in the state is open.
All right.
From my perspective, I'd love to have it up here in northern Kentucky.
Well, I can understand why you would prefer that, Mr. Matthews. When I was a trial attorney, I had a case that the venue was changed. Now, we did not go to an adjacent county because of media coverage that would have affected adjacent counties to Jefferson, and we ended up trying the case in Boyle County in the Danville Circuit Court. But okay, that gives me some idea of where you're thinking. All right. Anything else we need to address today, Ms. Whaley?
I would just ask if Mr. Matthews then would intend to have it filed within the 2 weeks so that we would have ample time to respond.
Sure.
Yes, I am awaiting some affidavits to go with the motion, but I think we can have that done within 2 weeks.
Okay, sounds good. All right. Anything else, Ms. Whaley?
That's all, Your Honor.
Mr. Matthews?
Nothing further, Judge.
All right. And Ms. Whaley, Mr. Matthews, I think I asked this of you one time previously. If you would send me the names of the people that will be coming with you, any witnesses or other attorneys, staff who would be coming with you to court on March 25th, so that I can let the deputy sheriffs at the magnetometers know who to expect to come to Circuit 13. And you could just email that to my administrative assistant, Melinda, if you would.
Okay.
Yes, we will.
All right. Thank you all. Thank you very much.
Thank you, Judge.
Thank you, Judge.
Thanks, Judge.
Bye, everybody.
Bye. Bye-bye.
Bye.
Your Honor. Hey, this is Anita Wise at Channel 32. How do you think you will handle that with the media for an in-person?
We could probably have one media person come in to the courtroom.
Like a pool shoot?
Mm-hmm. Yes.
Okay. Who do I arrange that through?
I think through the court administrator's office, Carla Kreitman, either Carla Kreitman or Angela Bilowich.
I know Carla. Okay. I will give her a call. Okay. Appreciate that very much.
All right. Thank you.
Bye-bye.
Judge, are you still on the line?
I am.
This is Brooke over at WHAS. I came into this just about a minute later than you guys started, so I just wanted to make sure the result of this meeting was just setting out that jury trial for August 31st with the hearing that you scheduled in March. And that was pretty much it, correct?
Yes. We just talked about the fact that all discovery had been turned over and things were moving along as expected.
Okay, perfect. Thank you so much. I appreciate it.
Sure, thank you.
Bye.
All right, good morning, ladies and gentlemen. Anything to report from the overnight break? All right, if not, then we will go ahead and resume with the direct examination of Sergeant Vance. And Ms. Whaley, if you're ready to proceed. Good morning.
Morning.
Yesterday we had looked at a number of the photographs that were taken at the scene, including all of the markers that have been placed outside the apartment 4, indicating the presence of bullet casings, as well as the bullet in marker 37 over by the wall in the foyer, in the breezeway. When those were all collected and sent to the crime lab by crime scene unit, the crime scene unit take close-up photographs of the 10 casings that were later determined to have been fired by former Detective Hankison that we saw in the parking lot?
Yes, each individual item of evidence is typically taken back to the CSU lab, and then they take closer photos, or where they can put it on their lab tables, and it's more of a physical examination with in the use of a photograph.
Permission to approach. I hand you the photographs that have been marked Commonwealth Exhibits 77 through 87. And then 89 through 93. If you would examine those photos.
Yes, ma'am.
And are those fair and accurate representations of the casings and bullets?
Yes, ma'am.
Okay, move to admit exhibits 77 through 87
No objection.
and 89 through 93.
No objection, Judge.
All right, they'll be so admitted.
So if you would, do you have the laser pointer up there?
I do.
Direct your attention to the screen and to exhibit 77. And this is a bullet labeled exhibit 21 by the crime scene unit. And as we saw yesterday, they have different numbers depending on the crime scene unit, the marker number. So is this a photograph of the bullet that we saw yesterday in exhibit 99 on the dining room table of apartment 3?
Yes.
Okay, exhibit 78. And again, this photograph was identified yesterday in photograph exhibit number 105 as being the bullet on the floor amongst the glass, the shattered glass in apartment 3 near the sliding glass door.
Yes.
And that's a close-up of that same bullet. Moving on to exhibit 79. Marked here as exhibit 23, and that we saw yesterday in the photograph of the parking lot with marker 1 next to it, one of the casings taken from the parking lot.
Yes.
Next to marker 1.
Yes.
Moving on to exhibit 80. This is now numbered exhibit 25. As we saw yesterday, it was the casing marked by marker 3 in the parking lot. This is a close-up of that casing.
Yes.
Now exhibit 81. The now labeled number 26, but it's the same casing as we saw in the parking lot next to marker 4.
Yes.
Exhibit 82. Is this now marked exhibit 27, the same casing that we saw in the parking lot next to marker 5 in that area between the Roto-Rooter van and the truck in the parking lot?
Yes.
And exhibit 83, now marked by the crime scene unit as number 28. This is the same casing that was in the photograph in the parking lot by marker 6.
Yes.
Exhibit 84, now marked number 29 by the crime scene unit, and is this the casing that was collected next to marker 7, also in the parking lot?
Yes.
Between the van and the truck. Exhibit 85, now been labeled number 30, and is this the same casing that was next to marker 8 in the parking lot?
Yes.
Exhibit 86, now labeled number 31, is this the same casing that was collected where marker 9 in the parking lot was that we saw yesterday?
Yes.
Now exhibit 87, another casing and a close-up, now labeled number 32, and is this the same casing that we saw in the parking lot? Well, the previous one we just looked at, 86, I failed to mention that this is the one that was underneath the tire by marker 9.
Yes.
Underneath the tire of the roto van. Okay, now go on to 87, and now labeled 32, that was collected next to marker 10 in the parking lot.
Yes.
Now moving on to 88. Not yet. 89. Okay. Now, this has been labeled number 69. And is this fragment of the bullet that we saw yesterday on the dining room floor in apartment 4 that was next to marker 40?
Yes.
Now, exhibit 90. Does this photograph contain the bullet that we saw yesterday in a photograph next to marker 47 in the dresser drawer?
Yes.
Exhibit 91. Also a bullet close-up and now labeled 82. Is this the bullet that we observed in the photo of the bathroom soap dish with the bullet in it
Yes.
yesterday?
Yes.
I think that photo was exhibit 60 from yesterday, that photo. Next, 92, exhibit 92, another bullet, which is now labeled 83. Is this the same bullet that we saw yesterday on top of the utility closet, on top of the furnace in the utility closet that I believe was in the exhibit 58 yesterday, the photograph of the utility closet?
Yes.
And now 93, another close-up of a casing that is now labeled by the crime scene unit number 87. Is this the 10th casing that you indicated there was a casing that did not have a marker by it that was located underneath the van?
Yes.
When the van was moved, is that when this casing was discovered?
Yes.
Okay. So that is a total of 10 casings collected from the parking lot.
Correct.
And all of those, a total of 10 casings and 6 bullets. The bullets being number 69 that was found, the fragment found on the dining room floor of apartment 4. Number 20, these are the lab number, or the crime scene unit numbers. The numbers 21, which was taken from the dining room table of apartment 3. Number 22, which was on the floor in the living room of apartment 3. The number 47 marker, now lab number 79, taken from the top dresser drawer in the south bedroom, that being the 4th bullet. The 5th bullet being crime scene unit number 82, removed from the soap dish in the bathroom. That's the 5th bullet. And the 6th bullet being crime scene unit number 83, being the bullet taken from the top of the furnace in the utility closet.
Yes.
So that's 6 bullets that we just saw close-ups of and 10 casings. Now there were, at some point after the crime scene unit collected this evidence, there were 3 additional bullets
collected by the FBI in an additional, more invasive search of apartment 4. Correct?
Yes.
You, obviously, you weren't
right, I was not
involved
part
in
of that. Yes.
But there were 3 additional bullets collected. Now, these that you have just described in the close-up photographs were all submitted to Kentucky State Police Crime Lab to be analyzed and compared to the gun.
Yes, they were sent to the ballistics examiner for examination.
And we will hear from another witness that the defendant's service weapon that he was using that night was also, of course, collected.
Of course.
And then submitted to the crime lab.
Yes.
Okay. Now, there was an additional bullet that you described from the breezeway from marker 37. I'm going to hand you this more Commonwealth Exhibit 88. Is that a close-up of the bullet collected in the breezeway by marker 37?
Yes.
And if you would look at the screen. Is that a close-up of the bullet collected over on the opposite wall from apartment 4 that's now designated as number 65?
Near marker 37?
By marker 37.
Correct.
Now, that bullet, as you stated yesterday, was also submitted for testing and was later determined to have been fired from the 9mm that we saw under the bed in the south bedroom of apartment 4.
Yes, ballistically, it was compared and found to match that of the gun, the 9mm the handgun that was found inside the apartment.
Okay. I move to admit Exhibit 88.
No objection.
All right, it'll be so admitted.
Now, did the crime scene unit and the staff, the officers of the public integrity unit, conduct a complete search of apartment 4?
Absolutely.
And would you expound upon that? What measures you took in processing that apartment?
So at the conclusion of the exterior scene processing, as like I said yesterday, that was the main focus initially because, you know, there are certain things we couldn't control in the exterior of those buildings, people coming and going and whatnot. So in the meantime, apartment 4, the door was not shut but pulled to where it would conceal Ms. Taylor's body. A 3rd Division officer, Officer Asia Clay, was positioned in the breezeway. And her job was to prevent any of the residents, if they did have to come out, they would have to make contact with her, and then she would make contact with me, and then we would kind of try to ascertain why they're coming out. This is during the overnight, so you know I think that only happened once, but she was there for a long time. So once we worked our way into the breezeway and started to collect evidence, we were there in the exterior, the common area. We worked our way into the apartment. Once we got into the apartment, the same process kind of worked. We took overalls. We put markers down as far as what evidence was obvious. So there's a process where anything that's this clear that stands out, we do markers, and then once the evidence that's obvious to any person in there, that's collected. And I should kind of go back a little bit. So while we're in the exterior scene, we do what's called a 3D scan. We use Farrell scanners. Farrell is just a brand. So I spent 5 years in homicide as a homicide detective, and I can tell you, typically scans, and there's variations in how many scans you do on scenes, but you wouldn't typically do more than 10. It just depends on the characteristics of the scene. But in this case, we did 25 independent scans, and the reason why is because each scan captured as much of the scene in a 3D environment. So we can go back in the scan, and using the proprietary software from Farrell, we can go in and we can measure in a three-dimensional application. We can measure things in free space and have a certain amount of accuracy. It's a very useful tool for investigators. So we did 25 individual scans, and that includes the interior processing. So I say that because it slows the scene processing down, because you are methodically documenting each item of evidence, and there's a duration of time in each part of that scene process. So once we make it into the interior of the apartment, that same procedure was done. So once we identify obvious evidence, we put markers down. That evidence is collected, and scans are done. In the duration after that is completed, we would methodically go through that apartment, and you can see this in some of the crime scene photos, where we tried to develop and present or show with photographs trajectories of bullet defect in the kitchen, in the common wall between 4 and 3, in the wall that separates the living room and the south bedroom, that bedroom that's immediately south of the hallway where Ms. Taylor was located. Trying to reconstruct or have a photograph and or a scan that will show the trajectory of the projectiles that were shot. I should note that in this process, Farrell had they have a proprietary trajectory program built into their scans, into their scan product. And unfortunately, that no one from LMPD had been trained on that, and we actually at a later date had to have Farrell come in and evaluate our scans and then interpret it for us. So
in that process, did you discover any guns other than the 9mm under the bed in the south bedroom?
No.
And you searched every inch of that apartment?
The legal authority that allowed the public integrity unit to search that apartment would have encompassed any projectiles, which a projectile can be anywhere. So the scope of our search was limitless. So what that meant is we could search anywhere in that apartment legally.
Did you find any evidence of narcotics?
No, and there was no narcotics listed on the property section of our legal authority. So the procedure on that would have been as we would have come in contact with narcotics, we would have written an additional legal authority to seize those narcotics.
And as we saw in the photographs yesterday, you did come across mail matter that was collected.
Yes.
That was addressed had Jamarcus Glover's name.
Yes.
And so you searched in closets, in corners, in drawers, and so forth.
Everywhere in apartment 4.
Now, the integrity of the crime scene was maintained throughout until you completed all the collection of evidence, the photographing, and so forth.
So a part of the investigation is that, investigators go back and review wearable video in relation to officers that responded to the scene. So that's why I'm able to say confidently that the integrity of the interior of apartment 4 was maintained throughout until it was released sometime in the afternoon that same day.
Did, in the course of also completing the investigation, did you obtain a photograph of the clothing that had been worn by Mattingly that indicated where the bullet entered?
Yes.
Clothing.
Yes, the investigators in our unit obtained that through a forensic examination.
I'm now going to hand you Commonwealth's Exhibit 120 and 121 and ask you to explain what is depicted in those two photographs.
Exhibit 120 is Sergeant Manley's pants that he was wearing that night of the incident, and it shows projectile defect in the pant with a scale for size purposes, and there's obvious what appears to be blood evidence on the pants.
So that would be the left leg then?
It was the left front pocket.
Front pocket of the pants.
Correct.
And now Exhibit 121.
This is a picture of, or photograph of Sergeant Mattingly carried his wallet in his front left pocket, or his front pockets typically, from what I've been told. In this case, it was in his front left pocket, and it should be noted that there was a metal ring affixed in that wallet, which was very important that night.
Right. So the bullet entered the wallet.
The bullet hit the wallet, and when it entered the wallet, as you can see in the photograph, this ring here actually deflected or changed the trajectory of that projectile.
It passed through the wallet.
It did.
Because it passed completely through his leg and ended up in the breezeway.
It exited the back of his left leg and ended up in the breezeway next to apartment 1.
So this is another indication of where it hit.
Correct.
The bullet. Okay. Move to admit Exhibits 120 and 121.
No objection.
Will be so admitted.
In further conducting your investigation, did you interview at the Public Integrity Office all of the detectives who had been there that evening, that night, serving the search warrant?
So initially, the involved officers, the officers that were directly involved in the shooting, were not interviewed. We Public Integrity Unit goes by what's considered the force science model, and we allow officers. Well, let me back up. Officers aren't required to speak with PIU investigators. They have the same constitutional rights that all of us have, and because we conduct criminal investigations, they cannot be compelled by their employment to speak with us. So the involved officers would not be interviewed regardless of whether they would consent to it or not that night, because we adopted the force science model. We found that when there's time between the critical incident and when, at least 2 sleep cycles, that the officers are able to articulate and be more concise and provide more information in relation to the shooting or the critical incident. So it's beneficial for everyone involved. But we did, however, conduct interviews with what we would consider as or categorize as witness officers that were there as well that night.
Okay. Back to the processing of the scene. Did you discover that there had been a bullet that exited out of the ceiling of apartment 4?
Yes.
Explain that.
So during the investigation, I can't say confident, or I can't say definitely, but it's likely that the 2 projectiles that entered the ceiling of apartment 4 that traveled into apartment 8, which is immediately above apartment 4, were likely from Sergeant Mattingly, because during this incident, when he was shot, he, in his own account, fell down on his buttocks from being shot. He was immediately injured, and he was critically injured, and he returned fire in defense of his own life. And it's likely that those 2 rounds that entered apartment 8 were from him because of the way he described the incident. And I was later told that at least one of those projectiles exited the roof of the building after the roof was examined by the FBI.
So there were no bullets retrieved that exited the ceiling of 4 into 8 and out the ceiling of 8?
No. PIU investigators were able to obtain consent from apartment 8, the occupant of apartment 8, and we went in and we photographed the defect, if you will, related to those 2 projectiles.
Was an interview conducted by Public Integrity Unit of the defendant, Brett Hankison?
Yes, there was.
And when did that interview occur?
March 25th of 2020.
What is his history with Louisville Metro Police? How many years had he been with the department?
I believe it's the time that this incident occurred, he had a little more than 17 years on.
And at the time, in March of 2020, what unit was he in?
He was, the narcotics unit had been rebranded several times. According to this document that I have from his personnel record, it looks like he was transferred to narcotics, which is now called CID. It was called CID when this incident occurred, but it was originally called narcotics. But he was transferred on June the 12th of 2016.
And he was a K-9 officer?
Yes.
At that time?
At the time of the shooting, yes.
Previous to that, had he been in what's called a flex unit?
Yes, he was a flex detective. At the time, the LMPD had flex units within each patrol division that would handle anything that the division commander had to address. Like, could be car break-ins, could be street level narcotics. They did everything, but it was primarily narcotics through each division.
And in that unit, there would be a lot of search warrants executed?
I would imagine so, yes.
Now, at the time of the interview that you said was March 25th, did he sign an agreement to be interviewed?
He did.
And he was advised of his rights?
He was, and an attorney was present.
He agreed to be interviewed?
He did agree.
And have you reviewed that, and it was done by video?
Yeah, video and audio.
And have you reviewed that video of the interview?
I have.
And is it a fair and accurate representation of the interview that occurred
Yes.
at PIU on March 25th?
Yes.
At this time, we would move to play the video interview.
No objection.
All right. And is it possible to lower the lighting?
1030, officer down. 1030, Officer Sean Springfield.
What's the location?
Officer Sean Springfield, 1030. Eyes EMS. EMS is around the corner, radio. We need EMS bucking up here now.
I'm getting them started.
Already down the street. Tell him to get up here.
Crystal Bay, use the door to Springfield Drive. We have EMS in the way.
1 David on Springfield. Where y'all at?
3007 Springfield Drive.
Do not block EMS. Ram that gate. Ram that gate, patrol car. Ram that gate. Patrol, ram that fucking gate now. Ram it with your car. Ram it.
Here, quick light. Here. We're gonna cut him. Here. Cut it with my knife. You okay, John? John, you okay? Huh? Hey, fuck this EMS, dude. 30 minutes away. Somebody give me the radio with SWAT on it. SWAT 1. Here.
Officers encountered rifle fire. Officer down. Bring long guns. Subject is still inside, radio, barricaded with a long rifle. Looks like an AR.
Subject still inside, barricaded with an AR.
Be advised. He is still inside. We've got cover on the door. We don't know if there's a back door to this place.
Looks like an upstairs apartment. Upstairs apartment. Text your family. Hey, upstairs apartment. You want me to get in the turret? Cover hide? Yes. What'd you say, Sarge? Text your family. And upstairs I think it's an upstairs apartment. Then I'll pull up and we get me fucked up. And what if it's like, okay. Person at apartment number 4 of building 303. Apartment number 4. Please come out with your hands up. You have to tap loud. I cannot hear you. Keep your fucking hands up. Coming out. Step to your right, 2 steps. To your right, 2 steps. Now step down on the step and keep walking backwards. Step down, and I want you to walk between these cars. Walk straight down the steps or backwards. Keep walking backwards. 1 more step, sir. Now I need you to walk back between these 2 vehicles. Keep walking backwards. Almost doing it. You're doing a great job. Yeah. Keep walking. Do not do anything else. Do not reach down. We'll get him right here. Right here. Keep coming back, sir. Keep coming back, sir. Keep walking backwards. You're scared. Right. Walk straight back, or I will send this dog on you. Walk back to my boy. Walk back, or I will send this dog. Walk back to me. Keep on walking. Walk down. Walk. Walk back to me. Let's get behind this car for cover. What did I do? Who else in the apartment? Nobody. My girlfriend's dead. Tell them we have 1-10-15. What? How's your girlfriend? I don't know. Inside? Yeah, somebody. When I was banging at the door, and she said, "Who is it?" And I just started shooting. No, we down 3 times. Please search. This pocket's clear. There's somebody in there dead? Yeah, my girlfriend. It's her house. That was her house. Who's shooting it up? We have to go in if there's somebody. Yeah. What is this about? I'm with you if you want to go. We're both just regular worker people. Where is she at in the apartment? She's on the ground. Where at? In the hallway. What kind of gun did she shoot? It's a regular 9mm. Did she shoot or you shoot it? It was her. She was scared. We didn't even know who it was. We didn't know who it was. Watch out. Got you. We was in the bed. We didn't know who it was. The gun's legal, like, and everything. We don't even know who it was. I don't know who it is. She asked 10 times. We don't know whose it is. Here.
Hang on. Here comes the fence.
Yeah, hey, heads up. Stay back a little bit.
Is Joe good?
Everybody okay?
Yeah.
You all right, Joe?
Watch out. Watch the door. Watch the door. Front door. Hey, I'm throwing it to the front door.
Hey, you're not gonna get over that lip. We're gonna have to go up there.
All right, that's fine.
One on me.
Give him one.
One on me. Get yours over to your right.
What do you need, Hogan?
Cover her.
Oh, sorry. Give me another body. I'm here.
Hold on. We're gonna stay here, Zoo. Go with the Sarge and clear that good room to the right. And he's posted. One on me.
I got you.
Hold on. I got her. One on me.
I'm here.
I got him. Fighting this door too.
Hang on.
Hang on. Yeah. Can you cover her?
Hang on a second. Baker, out of that room.
I'm good right now. I'm good.
Cover from the other side. We got a bathroom that sucks back.
Hold on, Mike. All right.
Closet immediately left.
You got two closets that folding doors.
All right.
To your left and an open bathroom. Looks to be mostly clear. I'm up. I'm down here.
Oh, I can see he's clear. Hogan.
Yep. Clear.
You ready?
Yeah. Let's get this bed real quick. Let's get this bed. Slip in our bed real quick.
Hang on, let's check the bed.
Yo, hey, have them pop that door. Anybody right there to your left? No. I'll come to it.
We still got to check the bed.
Check her. We got to check her. Check her. Make sure she's good.
Hey, lift the bed up. I'm going to go this way with my pistol or rifle.
Yeah. Go ahead and get EMS in here.
Clear.
You can roll her over. Joe. There you go, buddy. Check the pulse. Ma'am, can you hear us? Louisville Metro Police Department. Check that wrist, dude. Check the wrist. Medic up! Scene secure. She's 1080. We're leaving a couple people in here to hold the scene. It's secure for detectives to come up. So I think it's casing right there. Sorry. Like right there. You're all casings. They're casing. So,
Oh, that's their gun. Right here.
yeah, I'm right there.
That's theirs?
No, that's ours. It looks like theirs is in there. But I'd back out until they get PIU in here. So.
I just know if there are any guns visible.
We did not see any.
Is there any windows that go out that way?
The only casings look like 9 mils.
He said she was shooting. The suspect said that his girlfriend was shooting the ass with a 9mm.
Hey, this room right here, there's a pistol underneath the bed. I'm not worried about that right now. Yeah, I know. You know what I mean? It's a crime scene. Do not walk by yourself. This is our city. This is our town.
For months in Kentucky, residents outraged by the killing of Breonna Taylor campaigned for the police officers who shot her to face charges.
Commonwealth of Kentucky versus Brett Hankison.
In September, a grand jury investigation indicted one officer for shooting into a neighbouring apartment and no one for killing Taylor.
Is that the decision of the grand jury? motion and assign bond in the amount of $15,000 paid cash and issue a warrant.
No one has been held accountable. This is injustice, and this is a start clock for the next level of our protest.
What happened in the final minutes of Breonna Taylor's life? A full telling of that story has been impeded because none of the 7 police officers who raided her apartment used body cameras, a violation of police policy. But with the recent release of thousands of documents and images collected during 3 investigations, the Times initiated a fresh examination of the case. We used crime scene photos to create a precise model of Taylor's apartment. We forensically mapped out and retraced the first bullet fired by Taylor's boyfriend and the 32 bullets that police shot in return, through windows, walls and ceilings. Using interviews officers gave to investigators, we charted their movements as they carried out the raid. And we analysed hours of 911 calls, grand jury proceedings and footage by the SWAT team that arrived after the shooting.
Man, can you hear us?
Members of the grand jury have accused Kentucky's Attorney General, Daniel Cameron, of shielding the officers involved from homicide charges.
Our investigation found that Mattingly and Cosgrove were justified in their use of force.
Boom, 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 boom.
Sergeant Mattingly may have been justified in returning fire when he's fired upon, but our new analysis paints a more complicated picture about how this raid was compromised from beginning to end. We'll outline the flawed intelligence and tactical mistakes of a hodgepodge team of officers, their failure to properly announce their presence at Taylor's, the chaos and excessive use of force that ensued.
Okay, there's another hole right below the clock.
And we'll explore the damning analysis of an experienced SWAT commander who was called to the scene after the shooting.
We just got the feeling that night that something really bad happened.
The focus of the police investigation on March 13th is not Taylor's apartment, but properties 10 miles away in West Louisville.
Local Metro Police.
Hands behind your back, boss.
We're executing a search warrant. Come out.
Where dozens of SWAT and police officers arrest an ex-boyfriend of Taylor's and his associates and seize evidence including drugs. These officers are wearing their body cameras and they carry out the raid safely and without incident. What the SWAT team doesn't know is that at this time, a hastily assembled team of narcotics officers is about to raid Taylor's home across town. They suspect her ex-boyfriend keeps cash or drugs there, but their intel is poor. They don't know she has a new boyfriend and they think she lives alone. When 7 officers begin the raid at 12:40 a.m., they notice the lights are off, except for the flicker of a TV in a bedroom.
The light on the bedroom, the TV. I remember seeing it lit up blue, or when we pulled up.
Suggesting they know where Taylor is. In less than 3 minutes, she would be fatally shot. Inside, Taylor had dozed off while watching a movie with her boyfriend, Kenneth Walker. Adjacent is the bedroom of Taylor's sister, but she's not home. A hallway from the bedrooms leads to a living area, and the apartment's entrance is in this breezeway. The only light is this lamp opposite her door, where now the police begin to stack. In this reconstruction, we hear the official testimonies given by the 2 officers nearest the door, Mattingly and Nobles, Cosgrove, who's providing cover, and Hoover and Hankison beside them. And we'll hear from neighbours and Kenneth Walker, who was interviewed by police right after the shooting.
When we all got up in line, I knocked on the door, banged on it.
Just as Mattingly begins to knock, a man emerges from the apartment directly above. He doesn't live there, but is picking up his child after finishing work.
The door right there, that's why the babysitter lives. So I came to pick up my little girl.
A squabble with Detective Brett Hankison ensues, and already the team seems on edge.
I remember Brett extending his gun saying, "Get back in your apartment, get back in your apartment." Brett was a little bit worked up. I remember looking at Brett saying, "Brett, relax. Brett, just relax, relax."
The man retreats inside. The police are supposed to be conducting a knock and announce raid, but that's not what Mattingly says happens at first.
We didn't announce the first couple because our intent was to give her plenty of time to come to the door.
Inside, Taylor wakes up.
So it's a loud bang at the door. She pops up out of sleep. It scared her to death. Me too. Like, who is that?
Banged on the door, no response. Banged on it again, no response. At that point, we started announcing ourselves.
Whether the police announced themselves clearly enough is a critical issue in this story that we'll return to later on. Not knowing who's at the door this late, Walker grabs his licensed handgun.
Another knock at the door. She's like, "Who is it?" Loud at the top of her lungs. No response. So I'm like, what the heck?
They rush to get dressed and walk toward the door.
We never even made it like mid-hallway. But as loud as we were screaming to say who it is, I know whoever would be on the other side of the door could hear us.
Outside, some of the police do hear Taylor.
I can hear somebody inside. I kept telling John, I can hear her.
But after knocking and waiting for around 45 seconds, they decided they've given her enough time to respond and rammed the door open.
The last time, I just said, let's just hit it. And that's when we did the, police search warrant.
We'll show here what the police and Walker describe seeing next.
And I hit it. After the third hit, it flew open. And that's when it hit the fan.
As we're coming to the door like comes off the hinges like an explosion.
The officers now make a tactical mistake. Mattingly steps into the doorway and puts himself in what police describe as the fatal funnel, a position vulnerable to gunfire and hard to move from.
I could see down the hallway, and there's the male and a female.
All right, and who is the foreperson of the jury? And have you reached a verdict?
Yes, we have, Your Honor.
If you would give the verdict form to the deputy sheriff, please. Under verdict form number 1, we, the jury, find the defendant, Brett Hankison, not guilty of wanton endangerment in the first degree under instruction number 4, as that applies to Cody Etherton. Verdict form number 2, as to Chelsea Nepper, Napper, we, the jury, find the defendant Brett Hankison not guilty of wanton endangerment first degree under instruction number 5. As to verdict form number 3, wanton endangerment first degree as to Zayden F., we, the jury, find the defendant Brett Hankison not guilty of wanton endangerment first degree under instruction number 6. Counsel, anything further from this jury?
On behalf of the defendant, Your Honor. Thank you.
All right. Ladies and gentlemen, cannot thank you enough for the time and attention that you have paid to this case, for being able to reach a verdict, for going through individual voir dire with us, for filling out the questionnaire, always being on time for court, coming in during a pandemic and hearing this case, going to the scene with us. I just cannot express my appreciation to you enough that you have so well performed your civic duty in regards to all that you have done on this case. I would like to meet with you just briefly back in the jury room, so I'm going to ask Deputy Sheriff Anthony to take you back there, and then we'll talk further at that point. Mr. Hankison, this jury has found you not guilty. This court therefore finds that you are not guilty of these charges. You are free to go and your bond will be released. All right. Thank you all.
Thank you, Judge.
Thank you, Your Honor.
Ladies and gentlemen, anything to report from the break? All right. Ms. Whaley, cross-examination.
As we've heard, you testify you've been a police officer. You were a police officer for approximately 20 years.
Yes, ma'am.
Went to the training academy at Lexington Metro.
Yes, ma'am.
And how many weeks was that training?
My best guess, it was right around 32 weeks.
Worked at Lexington, what, approximately 3 years, I think you stated?
Yes, ma'am, a little less than that.
Came to Louisville and you attended the academy again in Louisville?
I attended the lateral Jefferson County Police Academy.
And how many weeks was that?
Somewhere right around 6 weeks.
And you stated, I believe, that over the 20 years you've served thousands of search warrants.
I did not say that.
How many would you say?
I'd say somewhere in the range, over 700, less than 1,000.
Between 700 and 1,000 search warrants, you've been a part of the search warrant team.
Yes, ma'am.
And all different types of locations?
Yes, ma'am.
And many of those search warrants that you served or were part of a team previously, you were not the canine officer, were you?
That's correct. A majority of those were not with canine.
Were not as a canine officer?
Yes, ma'am.
Now, among the list of trainings that you have attended in your career, which we heard testimony from Major Grissom about, was, and this is in Exhibit 145, which is the transcript from Kentucky Law Enforcement Council. You did attend in 2011 the Police Training Officers course, didn't you?
Ma'am, I do not recall.
What is the Police Training Officers course?